We are conducting this argument in this format because of the ongoing pandemic. Although we're conducting it in this format, the ordinary rules of our courtroom apply, which include that each side gets 15 minutes to argue with no rebuttal. And with that, I'm going to call the first case, which is 2019 P 1552, Commonwealth versus VANDEL v. FONTAINE. And we're ready whenever you are, Attorney Davenport.
Thank you very much, Your Honors. Your Honors, Mr. Fontaine's conviction was based solely on uncorroborated and unreliable DNA evidence. It was unreliable because what was recovered was from a mask, and it was a mixture of DNA evidence. Clearly, multiple people had handled that mask. Otherwise, there wouldn't be a mixture. And the problem is there were tons of other people who had access to that mask. There were 4 people leaving the building as police officers arrived. There was 1 person upstairs. There were 2 people in the basement living room area. And there was a 25-minute window before the police were able to arrive when who knows how many people could have come and gone during that time. Juxtaposed with that, there was no real identification. Although the Commonwealth relies on a similarity of description, quote unquote, in their brief, that's false. What the witnesses described were 2 black men of average height, which is really no description at all. One of the people in the basement was 5'6", and one was 5'9". They were both black males, and either one of those fits is close to the 5'6" inch or 5'7" inch description given by one of the witnesses. We're talking a matter of a couple of inches. There's no evidence presented at trial of the heights or races of the other people that were leaving the home or who were upstairs. And obviously the police have no idea who came and went during that 25-minute window.
Excuse me, Attorney Davenport.
Of course.
What difference does it make if that other people may have had access to the either the mask or the space where the mask was located, which is probably more accurate to say, right? The space where the mask was located. Isn't the only relevant question is who was wearing the mask?
Yeah, but we don't know
at the robbery, at the time of the robbery.
But we don't know who was wearing the mask at the robbery. All we know is that somebody from the robbery went to that apartment and discarded the mask. When the police arrived, there were a bunch of people.
Well, that's not all we know, right? All we know is that 2 people committed a robbery. They took a bunch of different things, including a cell phone that happened to have a tracking function. Using the tracking function, they followed the phone, and one could infer the robbers to this particular location. The mask was found in the location, as were the things that were stolen, and the defendant, all within 25 minutes, let's say, of the robbery.
Well, not just the defendant, Your Honor. Lots of other people
and other
were there.
people, sure. But we're looking at the evidence. What lens are we looking at the evidence through?
But Your Honor, it's just as equally consistent that only one of the robbers went to that apartment. They weren't tracking both robbers because both robbers had a GPS chip on them.
Sure,
they were
but
tracking.
The robber, would you agree that the robber wearing the mask went to that apartment?
No, I don't know if that's necessarily true either. All we know is that.
What is the equally plausible inference about how the mask got there?
That all of the robbers put all of the evidence, meaning the weapons, the stolen items, the mask, the clothing, and took that to the apartment. So all we know is that one of the robbers went to that apartment. We don't know which one, and that single person could have easily carried everything and stashed it in the apartment.
How does that help you?
Because we have no idea who that robber was. And my client, Mr. Fontaine, simply handled that mask at some point in history. And that does not mean that he was one of the robbers. There's no direct connection between him and the robbery other than this mask. And under Antius, you need more because the DNA.
Why isn't his presence at the time and at this particular time and at this particular location not also probative?
Because there were lots of other people there, and none of them were charged.
The only thing. So what?
Well, so what is?
It doesn't diminish the weight of the evidence against him.
It certainly does, because there's the only direct connection between him and that robbery is the mask, and we have no idea when that DNA was put on the mask.
Why is his presence with the proceeds of the robbery not direct evidence?
Because lots of people were present, and none of them were charged. The only thing that connected him was this misleading apparition of connection.
Maybe we're having a difference in the use of language. You keep saying it's the only thing, but I think perhaps what you're saying, it's the only additional thing.
Fair enough, Your Honor. But under Antius, you need more than just the DNA that's on the item.
Sure. What was in Antius? Was the conviction reversed?
In Antius, yes, I believe it was.
No, I don't think it was.
Then I apologize. I stand corrected.
Do you remember what the facts were in Antius?
Yes, Your Honor. There was a robbery at a fast food restaurant. They found a mask. They found DNA on the mask, and they used it to track the owner of the mask, and that was the only causal direct link between that person and that robbery. And I understand what Your Honor is inferring.
Is here, and nonetheless the conviction was affirmed. And here there's more evidence.
Your Honor, I don't know if I agree that there's more evidence, because I know that Your Honor is inferring that the fact that he was present nearby where the mask is located is an additional piece. But my point is that it's extremely diluted to the point of non-existence by the fact that there were other people, and the fact that simply because he's in an apartment with a mask that has his DNA on it doesn't tell us anything. If these people are all hanging out, staying together, living together, whatever, and somebody took a mask that he had worn once and used it to commit a robbery and then came back, it would be easy to rush to judgment and say that he was one of the robbers. And that's why we need more corroborative evidence than that. We need something more to say that he was connected. And what the Commonwealth has tried to do is to rest on the fact that there was an identification. What I'm trying to argue is that there is no real identification. In addition, there were no prints. In addition, there was no evidence that Mr. Fontaine was there unlawfully. The only thing that came into trial was that he knew somebody named OG. There's no evidence to say how the police knew he didn't live there. He could have been staying there. He had no duty to explain his evidence, and any attempt by the Commonwealth to shift that burden is impermissible. None of the evidence obtained, whether it was guns, clothing, were found on anybody's individual person. They were simply in a home where there were lots of people. As a matter of fact, he was on a different floor from the guns and clothing.
What was found in the room where he was located?
There was jewelry and a wallet downstairs on a dresser, but there was another person down there with him. And I know that the Commonwealth is arguing that this couldn't have been the person with the gun, but what they're overlooking is that this could have been the second robber still. Even though the witnesses said that they didn't think that it was Edwards who was holding the gun because that person spoke and it wasn't his voice. He could have easily been that second robber, taken all of the items with him after the robbery, went to the apartment, discarded them, and he was nearby where some of that evidence was found, just the same as my client. So the reason why DNA is problematic in any of these cases is we can't tell when it was placed on that item. And it could have been there for decades. We don't know how long it's been there. We don't know who last touched it. DNA isn't always left by touch. Shedders are more likely to leave their DNA, and not everybody's a shedder. And then there's the problem of secondary transfer. If the mask comes into contact with something else that has somebody's DNA on it, it's very easy for it to transfer. So that's why we need corroboration. The presence of DNA on an object by itself does not provide sufficient information to determine when the DNA was deposited on that item, and it's not enough to support a conviction beyond a reasonable doubt as a matter of law. So that DNA, or prints for that matter, in these lines of cases, must be coupled with some other evidence, something that directly connects the person to that crime. The Commonwealth would have to reasonably exclude the hypothesis of other circumstances which would lead to the possibility that that DNA or the prints were left at a time other than the crime. And the problem is that there are too many equally consistent propositions in this case. As I explained, it's equally consistent that another person in that apartment went, did the robbery, brought everything back, and just happened to have used a mask that my client had worn at some point. And as a result, an innocent man is in prison because the only thing connecting him is this appearance of certainty that science can create in some of this evidence, like DNA or prints. And while DNA or prints as a science might be very precise, the problem is that it can create this illusion that it means more than it really is. It creates the illusion that we can trust it to believe more than we should. And in this case, that simply having DNA on the mask means that Mr. Fontaine was one of the robbers, which simply isn't true. Without that DNA evidence on that mask, in other words, if the mask were obtained and there was no DNA on it, Mr. Fontaine would never have been charged, just like all the other people at that scene that the police found.
Go ahead.
No, go right ahead.
So in Anitus, we reversed the conviction because we said the combination of the DNA evidence and a grainy photo or grainy video wasn't enough. But here we have DNA evidence plus his presence in a room with the stolen items. Why isn't that enough?
Because the science of DNA is going to create this illusion that anybody whose DNA on a mask in that situation must have done it. And we simply know that that's not the science. The science is...
Why isn't that an argument for cross-examination and closing to the jury in terms of the import of the DNA evidence, as opposed to an issue of the sufficiency, where, as my colleague points out, there was a whole lot more evidence here than in Anitus?
The reason is there needs to be a threshold. It's the Commonwealth that has the burden of proof beyond a reasonable doubt, and they have to rely upon evidence which is over that threshold. And the problem with DNA evidence in a lot of these circumstances is simply equally consistent that Mr. Fontaine committed it versus that he didn't commit it, and one of the other people in that apartment simply used the mask that he once wore. And because these two propositions are equally consistent, they obviously, by simple matter of math, neither of them can rise above the level of beyond a reasonable doubt.
If I understand your argument correctly, it would mean that if the defendant were the only person in the if we just change the facts to be that the defendant was the only person located in the apartment, then there would be proof beyond a reasonable doubt.
If there were some factor directly connecting Mr. Fontaine to the robbery beyond the DNA of the mask,
there are actually plenty, because he's there right along the timeline, the phone tracked to that spot, he's right there at that time, and all the proceeds of the robbery are there, including the mask with his DNA.
Your Honor, I would suggest that there would have to be something more, just some other additional piece other than his proximity to a mask with his DNA on it. For instance, if one of the witnesses had identified a tattoo that they saw, if one of the witnesses said, yep, that's him because I recognized his voice or his body shape, or if he was still had the mask in his physical possession or was wearing it.
I think we understand your argument. You have very little time left. I'm wondering if you could address your second argument. And in that regard, I have a quick question for you, which is that can you not go to the trial court and remove the file, reverse the filing of the conviction, and then have it vacated as duplicative?
Your Honor, I would argue that was something that was tried by the trial attorney before the trial judge. And the trial attorney argued that they were duplicative. The trial judge agreed that they were duplicative, but the trial judge nonetheless did this like that. So the problem is...
Are you saying that the conviction was filed without the defendant's assent?
Yes, I'm saying that the conviction, that the trial attorney and the defendant never assented to a guilty file on this charge. They were,
Oh, I see that in the record. Which page?
my understanding is that it's we're talking about the second day of trial, so transcript 2, and we're talking, I want to say page 70 when they're talking about the fact that the trial attorney is arguing that they're duplicative, and where, no, that's a wrong site. All right, so Judge Giles acknowledged that the charges are duplicative on the transcript from January 22nd, about page 14. The parties were discussing that they wanted, that the trial attorney was arguing that the charges are duplicative, was asking the court to do something about it. Judge Giles acknowledged that they were duplicative, and then Judge Giles basically imposed a guilty file on each case, despite the fact that they were duplicative.
No, but my question to you was, you said that he did not assent.
Yes, Your Honor. I'm arguing that he did not assent.
I did not see that in the record. Can you give me a cite to it?
I'm arguing that his assent is completely absent. I don't know how I cite to a specific page with an absence, but that's when they were discussing it in the transcript. And I think it's pretty patently clear that the trial attorney was trying to get one of those two charges dismissed. I would argue that that's the normal course of action, is the trial judge dismisses the lesser included charge.
Okay,
even if
there, because your time has expired. Thank you.
Yes, Your Honor.
Are there any other questions? All right, Attorney Campbell.
Good morning, and may it please the court, Caitlin Campbell on behalf of the Commonwealth. I'd like to also acknowledge Caitlin Grasso, who is the trial prosecutor, who is watching today via the live stream. We ask you today to affirm the defendant's convictions. I'll start first with the sufficiency argument. All of the claims made by my brother today do not look at the evidence in the light most favorable to the Commonwealth, which the court must. And all of them are really arguments that go to the weight of the evidence, not the sufficiency of the evidence when you look at it in the light most favorable to the Commonwealth. As talked about in my brief and talked about in the questioning here today, this is a very different case than the Antius case in that it's not just—
Counsel, it's Anitas.
Anitas, I'm sorry. This is a very different case than the Anitas case in that it's not simply just DNA found near the location of a crime, which was in Anitas, and a grainy surveillance video, which was just of a make and model of the defendant's mother's car. That was the matching and the links there. Here you have very different evidence, which is within 15 minutes of the robbery, they're tracking a phone that's stolen. They get to a location, they track it to a specific location. The door looks like it's been kicked in. When they walk in, they see a gray thermal shirt, which is consistent with the shirt worn by one of the robbers, a black mask, which is consistent with what was worn by one of the robbers, a shotgun, which are all consistent with what was worn by one of the robbers, next to a bag filled with tobacco, which was an item that was stolen from the store. The defendant's DNA is found on the mask. There's also a partial inclusion of the defendant's DNA on the thermal shirt. The defendant, although it is a not the most precise description, he does match the description of one of the shooters. He's downstairs in a room next to an open dresser drawer, which has some of the stolen property in it. Not only that, when the defendant is asked about his relationship to the apartment, he has no explanation as how he came to be there. And this all happens within 30 minutes of the robbery, which takes it away from a case like Anitas. Turning, and that all suffices for the sufficiency of the evidence as to the robbery convictions. Turning to the guilty file, I didn't see I pulled up the transcript right now, and I don't see an objection on page 14.
But I also don't see any assent.
There isn't an assent. I would say that the best course could be, the Commonwealth doesn't argue that it isn't duplicative. We would be happy to, if a motion is filed within the court, to assent to that motion, and for that conviction to be dismissed as duplicative. I think that
if there's no assent, why is it? I mean, the reason why I asked that question is because we, as you argue in your brief, we can't review a conviction that's been filed, a filed conviction that was filed with assent. But if it wasn't filed with assent, then we can. So, what is the Commonwealth's position on that? Because that would be, you know.
I don't see an objection to it. I agree that
I don't see assent.
Sure.
I don't see explicit assent. When it's actually entered later on, I don't see, it just seems to happen. There's no
correct
request. There's nothing seems to happen without any real discussion. And the defendant did argue that the convictions were duplicative, which they are. So I'm concerned with that.
He does. I agree that the record isn't clear. If the court were to reach it, the Commonwealth does agree that it's duplicative, and so it would be appropriate to vacate that charge.
Okay.
And if the court has no further questions, I'm happy to rest on my brief.
Let me see. No, we all seem to be in shadow today, so it's a little hard for me to see, or perhaps it's just me who is in shadow. But in any event, thank you both for your helpful arguments. We appreciate it, and the case is submitted.
Thank you very much, Your Honors.
Just one moment, please. The case is now being recorded.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Your panel today is Justice Milkey and Justice Sullivan, and I'm Gabrielle Wolohojian. Although we're sitting in this format, the ordinary rules of our courtroom apply, which include that each side is limited to 15 minutes of argument with no rebuttal. And with that, I'm going to call case number 2019 P 1693, Commonwealth versus Alex Y. Delgado. Attorney Ingraham, we're ready whenever you are.
Good morning, Justice Wolohojian, Justice Milkey, Justice Sullivan, Tyler Ingram for Mr. Delgado. I apologize for not standing. I haven't figured out how to make my technology situation accommodate that. The case we're dealing with this morning is a case where there's an inescapable controversy in fact that was presented in the form of sworn affidavit and through the constitutional principles that underlie criminal trials, as well as the rules of criminal procedure, before a justice of the District Court of Massachusetts. The strongest claim on appeal, and what I will probably relegate all of my argument to, is the denial of the evidentiary motion on that motion for a new trial. Obviously, all of the other claims in the appeal are subsidiary to that claim. Presented in affidavit, we have a fundamental contradiction. Either there's an inculpatory video that at the very least added significant help to the identification of my client in an identification case. Either that video was not provided at the time of a plea, which is a critical stage and which requires the effective assistance of counsel, or that video was provided in advance of a plea and thereby represents ineffective assistance of counsel, either through inadvertence, through a lack of technological savvy, or a lack of attention.
Are you talking about, I just want to make sure I understand. when you're talking about the video, because the video that we've seen has four components. And there's a suggestion by the Commonwealth that there's only one recording that happens to show all four screens simultaneously. So, but you're, I think, always referring to each screen as an individual recording. Is that correct?
You know, you asked me a yes or no question, and I'm sorry, but I can't provide either. I think that my issue, the issue I have is you'll see that in the record appendix, there's a letter from the trial attorney, where he identifies receiving in advance of the August 22nd, 2017 pleas, a single video that showed one frame of action. And in the affidavits from that trial attorney, John Morris, from my client, they make it very clear that until November 30th, 2017, the first day of the trial, they were unaware that there was more video evidence that existed. They were aware that there was a photo still, that there was a still photo that, as it turns out, is from the same angle as the additional video that they received on the day of trial. However, they were unaware that there were more video than that. And there's a categorical difference between that video and the video from the outside of the store.
Right, you're not disputing that they had the video for not the video, but that they had the images from the outside of the store before the decision to reject the plea. You agree with that? And you were also agreeing they had the still from the video feed inside the store before he rejected the plea. Sorry, Judge Milkey, I think you had a question.
There's a lot of focus on the inside of the store versus the outside of the store. It might be more helpful actually to talk about before the event and during the event, because that's really the distinction here. You say at the time the plea was rejected. In fact, there were multiple offers of the same plea, correct?
Yes. Yes.
So when was the last time the plea was offered and rejected?
The record in this matter supports what was before the judge who decided on the request for an evidentiary hearing indicated that Attorney Morris had an offer that was on November 15th. So that was 2 weeks before the trial. That's supported by the transcript in this matter. The issue here is that he didn't have the video that was extremely inculpatory at that point. And so I think that or at least he was under the impression he didn't, right? He might have had the video. I'm a trial attorney primarily, and one of my assets to the defense bar is showing the elder statesmen of the defense bar how to use the technology that they receive in their cases. So I can't say, and I think that the issue here is we can't answer that question with the materials before us. We know the contours of the issue. We know that there was some issue in this case that either amounted to not having the information that was necessary to make a learned and principled decision about how to plead the case out. Yes, sir.
Yeah, in terms of your premise about what you call the inculpatory value of the video before the event, showing your client buying something from the clerk / his girlfriend or ex-girlfriend. What's important for purposes of rejecting the plea was what your client knew at this point. He certainly knew that he had dated this woman. And from that perspective, even though the video still is somewhat blurry, I'm not even sure sitting here today that it was necessary even to have her use the still to identify him if she knew her boyfriend was there immediately before the incident outside the store.
Judge, I understand that concern. The fact that you are to any extent equivocal about this especially when paired with the material submitted in support of the motion for new trial, which includes my client's criminal activity report, which is lengthy, which indicates that he had pled out several times to assaultive crimes, sometimes close to the maximum that you can get in a district court setting. This person didn't have anything to lose with an additional guilty plea on his record. What he had to lose was time. And he was in a situation multiple times where the attorney that the prosecution indicates is learned or experienced counsel. I forget what the term is, but this is an experienced attorney. He's not indicating in his affidavit that he told the guy to take the plea. So why did this person who could get out for time served with no additional kind of qualitatively different blemish to his record, why did he reject that plea?
I don't know what the answer might be to that question, but why does the answer necessarily mean that his counsel was ineffective?
It doesn't, Judge. It doesn't, because the other important thing that comes out of the record that was submitted to the trial judge in this matter indicates that the counsel wasn't ineffective. He just didn't have the material he needed to adequately advise his client. Now, whether that takes the form of, an ineffective.
I think that goes back to to my first question, I hope, but also to Judge Milkey's question, which is, what does the rest of the in-store, let's even assume that the trial counsel did not receive the in-store feed, which we don't know if that's true. He may have, and he just couldn't see it. Mm-hmm. But let's assume he didn't have it. What does it meaningfully add to the case or to the calculus in whether or not to plead guilty? Okay. You have the video, it's undisputed, you have the video showing the actual crime.
Well, indeed, Judge, and it's my client's decision to plead guilty or not to plead guilty. I present the evidence to them. And if I have a situation, if I'm looking at that same case, and I was the trial counsel for Mr. Delgado, and I have the video from the inside of the store, and I also have an offer to take a credit for time served plea in this matter, I'm going to do it 100 out of 100 times. And I think that any reasonable counsel would provide that same advice. And, Mr. Delgado pled to most of his underlying cases. This is not someone who is, standing on his principles and saying, I'm going to hold the government to their burden. This is someone who's completely willing to plead the case out. The difference between that still, that's up to you, justices. If you can look at the still and think that in the context of the case, there's not a significant prejudice with the addition of the video to, from the inside of the store, if that doesn't change the case for you, then we're just wrong. But I submit
that's actually, counsel, I think the difficulty is that that's not actually what we do, because we review the denial of a motion for new trial for abuse of discretion. And I'm looking at trial counsel's affidavit. I just had it. Oh, here it is. He says in paragraph 2 on RA 102, specifically, I informed Mr. Delgado that the interior video showed a suspect the Commonwealth believed to be Mr. Delgado wearing a distinctive colored jacket, which matched the assailant's jacket from the video depicting the affray outside the convenience store. Once trial counsel says that he told the defendant that, on what basis would we determine that it was an abuse of discretion for the motion judge to have decided that there was not a material difference between the still photo and the full video?
Yes, thank you, Justice Sullivan. The basis is, the difference in the basis is that the constitutional violation already occurred on the 15th and on August 22nd. In weeks and months preceding that, my client had been incarcerated when he could have been walking on the street as of the 30th, because they didn't have that video.
Well, but if that's not really my question. My question is, if the defendant is informed that the same distinctive jacket, and it is distinctive, is in the still photo as in the video, And the client says, and he goes on to say, the client then says, no, I want to go to trial. Why is it an abuse of discretion to say it doesn't matter whether he had the video or not?
Judge, this is also, I mean, I appreciate that. And, you know, but that is a controverted fact on the record before the court. And the fact that Attorney Morris didn't even raise, and this is something that the Commonwealth notes in their briefs too. Attorney Morris didn't even note the late disclosed inculpatory evidence in this matter. You know, this is a situation where we all have difficult clients, and sometimes those difficult clients fire us in difficult situations, but you walk into court and you say, I just got something that changed the complexion of my case. And it does. I mean, it's not, this is not nothing. And I think that's why, if you look at the affidavit that I submitted in support of both the motion for new trial and this brief in my record appendix, you see that the conversation I had with the prosecutor who handled this matter indicated, of course, I submitted the video. I was required to do so by the rules of criminal procedure and the Constitution, right? So, you know, if they didn't intend to use this video as an exhibit, then why was it such a significant part of the trial transcript? I mean, this is something that was clearly prepared. The prosecutor walks the jury through the inside of the store. Oh, you're going to buy a soda here. He does it both with Mr. Martinez, the victim in this case, and he does it with the clerk who made the identification.
But counsel, if you actually go to the transcript, it looks like the prosecutor was in fact intending to use the video still, and then there are objections based on authentication, i.e. did the still in fact come from the video? And the prosecutor on a dime appears to have changed his mind, I think it's a him, and said, okay, I'll just use the video.
So I think that suggests a significant familiarity with the video, Justice. And I think in my mind, that's an intended trial exhibit. The Commonwealth even says you can't extricate the one video from the other video. So if one comes in, they're all coming in. And that's what happened. These aren't separate exhibits. I would just like to direct the court with the time that I have remaining to the Mahar case. I'm not sure if I'm pronouncing that correctly. I'm from the South, but Mahar. And in that case, it actually stands for the opposite principle that the Commonwealth seeks to rely on it. Justice Cipher actually cites the Mahar case multiply in her series on criminal procedure and practice in Massachusetts, including for the proposition that you have the right to effective assistance at a plea, regardless of whether or not you reject the plea. I'm happy to provide that citation to the court. Thank you for your attention.
Counsel, I have two quick questions. One is a technical one, and that is, from the police report and other indications in the record, it appears uncontested that the photograph that the police officers first showed Ms. Perez was the still from the video. Yet at trial, it appears that when they were asking her about this, the photo that came in as Exhibit 2 was in fact a booking photo. It seems very confusing to me. Is there any light you can shed on this?
Yes, Justice. I think that the facts contained in the record support the notion that a single photo was displayed to Ms. Perez, the photo from the inside of the store, and then an array was displayed that included a booking photo of my client.
But what you have indicated is Exhibit 2 in the record appendix is actually a booking photo. It isn't the video still.
If I might have miscited it, actually, that's entirely possible, but I apologize. I'm not positive about the nature of the question.
Okay, other quick question goes to the juror issue. Faced with what the juror said and with all its specificity, you can easily imagine trial counsel saying, oh, this juror provided a very nuanced response to this question, this is exactly the kind of person I want on the jury who might bend over backwards on these issues. In trial counsel's affidavit, there's no mention of the juror issue and what was being thought of in this. What are we supposed to do with that?
I mean, I think what I'm reticent to tell you what you're supposed to do, Justice, but I do think that what you should do is look at the transcript and walk away from the transcript with the notion that this was not someone who believed that essentially race contributed to a likelihood to commit a crime, but that both race and class did. And I think that, you know, this goes to whether or not an evidentiary hearing should have been granted in this matter. I understand that there is an interpretation of that same transcript where it's a nuanced response and it's, you know, and it's a nuanced juror, but I think unfortunately without adding emphasis to places that's not present in the transcript, I don't think you can get there.
Anything further? Questions? No. Thank you both. Oh, no, sorry. Steinfeld.
Thank you very much, Your Honor. Good morning. May it please the court. Kenneth Steinfeld for the Commonwealth. I intend to be very brief this morning. It appears that the court is aware of all of the arguments that I intended to make. Of course, I'm not saying that the panel has shown that they agree with those arguments, but they've demonstrated unawareness of them, so I don't want to repeat them at great length. My brother's main claim is that he was wrongly denied an evidentiary hearing. I just want to remind the court that the standard to show error in the denial of a hearing, he must show that that decision was manifestly unjust or infected with prejudicial error. And he simply cannot do that, and he has not done that.
Mr. Steinfeld, can I address something? Is the video that was included as part of the record appendix, is the video of only what happened during the crime? Do you acknowledge that, first of all?
My impression was that it also included the prior, when they were both in the store.
That does
If that's not the case, then he certainly, if the actual exhibit, and I did not go over to the court to look at it because of COVID, they had shut down and they weren't allowing us to go and look at evidence, but the one from the prosecutor's file had a disc that said this disc was admitted at trial, and it had two short videos of it, one from before and one that showed the fight.
So in fact, there are two chunks of video.
Right.
One before and one after.
The still came from the first chunk.
No, I understand that, but what was initially included in the record appendix was only the second chunk. We have obtained from the trial court both chunks of that, but there is frankly a lot of confusion, even on appeal, in terms of what was turned over to whom when. So don't we have to assume that the prosecutor below didn't, for purposes of whether or not an evidentiary hearing was warranted, we have to assume that the prosecutor did not turn over the full video of what happened before the crime?
You mean that he failed to turn over the first chunk?
Yes.
I don't know if we have to assume it, but if we do, I don't think it affects the outcome of the case at all. So I don't think that you need an evidentiary hearing to establish exactly which one. I can tell you that the only videos in our file have both of them. And if that's the exhibit that you got from the clerk's office that has both chunks, then I don't see how it's possible, frankly, for us to have turned over something else, something that only had the second chunk. But as I say, if you do assume that, he still has what he has, and he knows exactly the strength of the Commonwealth's case when he turns down the first plea offer in August. So even if we only turned over the second chunk and not the first chunk, I don't think it makes any difference at all in his assessment of the strength of the case against him. I'm not sure if that answers Your Honor's question sufficiently.
Well, how do you address the fact that the still from the video is certainly somewhat blurry?
Well,
So go ahead.
I suggest that the court actually obtain the actual still that was introduced at trial as well. It's blurry, but it's not very blurry. I've seen much blurrier photographs. It's certainly sufficiently unblurry for Ms. Perez to have identified it immediately as the guy she knows who hangs around the store named Achilles. I'd also point out that in the police report itself that was turned over very early in the case, the officer says that when he went to the 7-Eleven for the second time and actually found the incident, he took the still from the footage that he watched. That still shows him inside the store. So both the defendant and his counsel must have known as soon as they saw the police report that there was a video of the interior of the store. And I think the fact that Attorney Morris did not object and say, Judge, I've just been given this interior video, does not show that he was incompetent, but rather he realized that it was not that inculpatory at all, that it didn't add much, if anything, to the Commonwealth's case. I'd also point out that in the same police report, it identifies several other witnesses who worked at the store, Ms. Marte and Ms. Ortiz, who also could have identified the person in that striped shirt as Achilles. And in his own affidavit, he says the defendant says he turned on the first offer, though he knew that there were witnesses, plural, who would identify him from the store. So the idea that the surveillance video from the interior of the store added anything to the case, I don't think that it holds water at all. And defense counsel now asks this court to deduce from the fact that he pled guilty earlier, that he would have done so in this case. I don't think there's any reason to believe that. This defendant actually, the record showed, was a difficult client. He was very angry that his case had been postponed several times, and he once was found in contempt by Judge Broadbent on a trial date. And Attorney Morris said in his affidavit that he did not move to suppress because his client wanted to go to trial and knew that the witness knew him very well. So I don't think that the leap that he seeks to make from his prior guilty pleas to say, well, then he would have pled guilty, that we can be sure now that if he knew about the interior video, he'd have pled guilty in this case. I don't see any way that that's a logical argument that this court ought to credit. There is one case I'd like to bring to the court's attention that came out fairly recently on the first issue, the issue of the juror bias. Commonwealth versus Mason, 485 Mass 520. And in that case, that involved a case where there was a defendant who was Israeli and a member of the Israeli Defense Force. And there was a possibility that there might be some anti-Semitic prejudice on the jury. And the SJC said that in order for the defendant to prevail in that case, he had to show prejudice from his claim that his counsel failed to exploit this possibility and to seek it out. And so I just want to say that there definitely is a prejudice element to the first claim. Even if he could show that this witness, who might have, I'm sorry, juror 13, might have harbored some bias against Latinos, and there's no evidence of that in the record, even if he had shown that, and that his counsel should have followed up, he still would have to show that he was prejudiced by it, and he has not, and he cannot do that. If the members of the panel have no further questions, I'm happy to rest on my brief.
Just on the juror issue, what
Sure.
can we surmise from?
I'm sorry?
What can we surmise from juror 13's comments? Because, you know, he does go to the issue, he raises the issue of some kind of correlation with socioeconomic
Sure.
factors, and that seems to subsume an assumption about correlation between being Hispanic and being poor. Would you admit that much?
I don't think that it assumes a correlation. We don't know what the juror was thinking. He was saying separately. That assumption assumes that everyone assumes that if you have a Latino defendant, he's poor. The argument has never been he was biased against him because of his socioeconomic status. It has only been biased against him because he is Latino. As you said earlier, Justice Milkey, I think it is a very nuanced position for that juror to take. And I think that it stands in sharp distinction with the Clark case, which has a lot of similarities. In that case, the juror said, I believe that African-American men are more likely to commit crimes because of their low socioeconomic status, where that juror directly tied the two. And here, we don't have that. So I think that the judge acted within his discretion when he didn't follow up. But the question is actually, the claim is not that the judge did not follow up. It's that defense counsel failed at that point to seek to excuse him for cause or to challenge him peremptorily or to ask for further questioning. And there's no basis based on what he said for the defense lawyer to have done that. He might have done that and the judge might have said, sure, let's find out more about what he thinks, but he didn't have to. And
well,
as that case,
counsel, isn't it fair to say that the judge fairly affirmatively wanted to move on from this line of issues and kind of shut down the inquiry?
I think I don't really see that. He actually had a pretty extensive voir dire with this very juror. They talked about the fact that he was a physical therapist and that he would have to move around a bunch of appointments. They talked about the fact that his wife was 37 weeks pregnant and that they'd make arrangements so that he could have a cell phone with him, so in case his wife went into labor. So the idea that the judge rushed through the voir dire of this juror is simply not true. If you take a look at the rest of the examination with him, I think what can be deduced fairly easily by that interaction that we're talking about, that he was convinced, based on his statements and his body language, that he said affirmatively that he could be a biased juror. He said unequivocally that he could be an unbiased juror, and the judge had decided, okay, I'm fine on that point. Now let's talk about these other matters, your profession and your wife. So no, I don't agree with the court's suggestion for those reasons. And as I say, if the members of the court have no further questions, I'm happy to rest on my brief.
Let me take a look. I don't see any.
Actually,
I do.
Super.
Yeah, just on the technical issue of Exhibit 2, do you think what is identified as Exhibit 2 in the record appendix is a booking shot and not?
Yes, that's just the wrong exhibit number, I believe.
I'm not actually sure of that, because if you look at the police report in detail, the police first showed some of the other witnesses a booking shot, and there may have just been some confusion, but we obviously can obtain Exhibit 2.
I'm not sure. I'm sorry, Your Honor. Where does it say that they showed a booking photograph to other witnesses? I'm not sure if that's in the
This
record.
is in the police report, not at trial.
Right, but you're saying that it says they showed the booking photograph to those other witnesses?
I believe when they approached the first witness at the 7-Eleven, keep in mind that Ms. Perez, they didn't track down until sometime later. They showed a booking photograph.
Well, the record says what it says. I don't have that as a memory, having read it fairly recently. I may be totally wrong. I'm aging. It certainly may be in there. But of course, if it's there, it's there. If it's not, it's.
Any event, we can track down Exhibit 2.
Yeah, no, it's in the document itself, so I can't really speak for it. If it says that it says that, but we know that the still itself was admitted as an exhibit, and the.
Do we know that? Because the only exhibits, at least again using the record appendix as a guide, are other items. The still photograph shows up in the new trial materials apparently, because it is included in the record appendix, but it is not identified as Exhibit 2.
Well, I'd have to go back and check the transcripts to see whether it was admitted. I was under the impression that it was also admitted because it was shown to the jury. But if I'm wrong on that, then I'm wrong on that. I don't think it changes the ultimate calculus, though.
Any further questions? Thank you both for your arguments. It's an interesting case. We've been helped by your arguments. We're getting a lot of background noise, so you might just want to be careful about that, Attorney Nguyen.
Certainly. Shall I mute it at this point until it's my turn?
Might make sense to, as long as you can continue to hear. I will.
The case is now being recorded.
Thank you. Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are hearing argument virtually, the ordinary rules of our courtroom apply, which include the fact that each side only gets 15 minutes to argue and there is no rebuttal. I'm going to call the case 2019 P1529, Commonwealth versus FROEBEL Antoine. And I'm just going to ask each counsel to identify themselves to make sure that we have the audio working properly now.
Good morning, Mary Nguyen for the Commonwealth.
Thank you.
Good morning, Marcel Joseph from Mr. Antoine.
And although, just for the record, I want to note that although Attorney Nguyen cannot be seen on this video, she has confirmed that she can see everyone else and that she can hear everything and we can hear you. So with that, Attorney Joseph, we are ready to go whenever you are.
Thank you. Good morning, justices, and may it please the court. My name is Marcel Joseph and I represent Mr. FROEBEL Antoine. I'm asking the court this morning to reverse the trial court's order denying the defendant's motion for new trial. Mr. Trial's counsel was ineffective as his performance fell below that of a fallible lawyer under the standards set forth in Commonwealth versus Sufficiency. And this was highly prejudicial to Mr. Antoine because justice was not done in this case. First, trial counsel failed to present evidence of the history of conflict in the family that ultimately culminated in these false allegations being brought against Mr. Antoine. This conflict is one of several instances of evidence of the complainant's bias and motive to lie against Mr. Antoine in a case that rested entirely on the complainant's credibility. This conflict started when Mr. Antoine first moved to Brockton to live with his brother, who is the complainant's father. And I should say at this point, I use the complainant as There are impounded materials in the case, and the name has been impounded as well. At this time, so when Mr. Antoine moved to Brockton, he believed that his brother and his brother's wife were basically scamming him for rent money because they lived in subsidized housing, but were charging him a higher amount for rent. This caused him to move out after being there for only a few months. Then we fast forward a few years later, and he made an agreement with his brother to move back to the house so that they could start a business together, and so that Mr. Antoine can do repair work in the house, which he asked for $3,000. He did the work, but he was never paid. It was around that same time that Mr. Antoine and another niece of his caught the complainant and her brother touching each other inappropriately. Mr. Antoine scolded the children for this, and he and his other niece reported this to the mother. She became upset with them, and it caused a friction within the family. Now, the Commonwealth's brief argues that this evidence was prohibited under the Rape Shield Law, which is Massachusetts General Laws, Chapter 233, Section 1B.
Before you get there, before we get to that issue, we're looking at this in a motion for new trial. We review for abuse of discretion, and we have to first look at whether or not this was a strategic decision. And counsel testified that it was never going to be his strategy to attack the victim. If you could address that, and if you could also address for me how it is that a claim that the victim, the alleged victim in this case, was a alleged victim of incest, forms the basis for a bias against the defendant. I mean, it strikes me as evidence that she'd been victimized twice, not evidence that she'd been biased.
Sure, and I can certainly understand that. So let me address your first point first, which is about the strategy. Trial counsel did not allege any particular strategy. I think during the actual hearing, the only thing that he said in response to questions concerning why he failed to present this evidence in defense of his client, evidence of potential bias and motivation to lie on the part of this complainant. He didn't have an explanation. He did try to use he did briefly and generally make a comment that that was the Commonwealth's argument as well, which is, I couldn't have done it anyway because it was prohibited under the Rape Shield Law, which is incorrect. It's not prohibited by the Rape Shield.
We'll get there in a minute. But his trial testimony, and I agree, it reads a little bit more like a deponent in a civil deposition than your average counsel explaining why he did what he did. But if you read the whole thing, he eventually says, well, my client told me he didn't do it, and my trial strategy was to put him on the witness stand and have him explain that. Why is that an ineffective trial strategy?
Because I believe because he was asked multiple times about his strategy, and his response was, his strategy was not, I'm going to put my client on the stand and have him explain. I believe his response was, my strategy was to just go to trial.
My strategy was to try the case, and the way you try the case was putting the witness on and having them deny it. So how does it fall beneath the standard of the ordinary fallible lawyer to decide not to put in evidence that the victim, the alleged victim, claims there is some evidence that she may have been abused by another family member? Why is that so manifestly unreasonable when made, which I think is the standard that we would find it ineffective?
Well, the victim, I don't believe that the alleged victim in this case would have agreed to that assessment of the evidence. That is information that trial counsel received from his client and his client's family. Had he questioned her about those incidents, I'm assuming here that she probably would have denied that they occur. So it would have been on trial counsel to convince the fact finder to find their evidence credible and the Commonwealth's evidence not credible. So I think the question you're asking assumes that the alleged victim would have agreed that she was the victim of some kind of incest, but that's not what's on the record.
Well, I only put it that way because that's the defendant's theory. Let's say she denied it, then the defendant has taken a significant gamble, and it has backfired. I mean, I just, you know, there's that old adage, you never ask a question on cross where you don't know the answer. How can we say it's ineffective for counsel to have failed to ask the question?
And I would say to that also, because this is not the only, the defense is not, this is the only evidence of bias. This was evidence of bias because after this was discovered by Mr. Antoine, he reported it to the family, and that was one instance that caused conflict. There are several things that caused conflict within this family, which made Mr. Antoine, which made that the complainant and her mom specifically have animosity towards Mr. Antoine. This is just one instance that caused that conflict. So my argument here is that this is just one instance that caused that conflict out of many instances, and all of those instances together are various examples of where her credibility could have been undermined by showing this is why she had a reason to lie that this ever happened. Because you're right, the defense was that he denied this completely. So and this case rested entirely on her credibility. There was no other evidence in this case to corroborate anything that she said. So if that's the Commonwealth's case, if the Commonwealth's case rested entirely on her credibility and trial counsel had the opportunity to undermine that with this evidence, then it was manifestly unreasonable for him not to do so and to only attempt to defend his client with just a blanket denial when he had other tools at his disposal.
Attacking an alleged rape victim is always tricky business, correct?
Absolutely.
And isn't it quite a leap to ask a jury to say, oh, because there was conflict within the family, therefore the alleged rape victim is lying about being raped? I mean, that's a pretty big leap, isn't it?
Well, first, I would just make a minor correction that this wasn't an allegation of rape. It was, he was charged with indecent assault and battery. But I don't think it was a leap. Again, because if we look at all of the instances as a whole, to look at exactly what happened from beginning to end that caused all of the strife in the family, and at the very end of it, Mr. Antoine, out of the blue, ends up being charged with indecent assault and battery. I think that's what makes it make sense. I think it's the history of the conflict, not only between Mr. Antoine and the family, but there was some internal conflict as well within the family that included his brother, which is a point I was going to get to, that, eventually the parents divorced. Shortly before that, there's evidence that this complainant displayed openly animosity towards Mr. Antoine. She hated him. She couldn't wait for him to move out. All of these things that was testified, that there was testimony to that effect at the motion for new trial.
But that evidence cuts in both directions, doesn't it?
It does cut in both directions, but when you are in a situation where you are adamantly denying the allegations and that's what you have to go with, I think that it would have been a reasonable strategy to go forward and undercut the Commonwealth's case again by showing that their whole case rests entirely on this one witness's testimony, essentially.
Just in terms of timing, the incident involving the unpaid labor was 5 years before the allegations, correct? And how much longer before the allegations was the moving in and out of the apartment?
So I think he moved out once and for all in, I believe, 2000 and.
No, what I'm referring to is you say you thought the brother was scamming for rent and he moved out. When
Correct.
was that?
That was in 2000. So in the same year that the first allegation was made, well, it was alleged to have occurred.
Was alleged to have occurred, and the doing the work and not being paid occurred when?
That occurred, I can tell you exactly. And I'm sorry, I don't know this off the top.
That's all right. If you agree it's roughly 5 years previous, that's enough.
I believe so, yes.
Okay. I mean, that's what the briefing says on both sides. I just wanted to confirm it.
Okay.
Do you think the relevance of this information, that the timing, in order for this information to be relevant, it would need to be tied to the timing of the accusation as opposed to the timing of the alleged acts?
I'm sorry, can you repeat that question?
Sure. So the instances or the examples of potential bias that you're pointing to, so family conflict, conflicts over payment for work as a handyman, rent, would those things, in order to be tie into your theory of bias, which I take it is that the victim manufactured the allegations because of these things, would that therefore the timing would need to be tied to the accusation as opposed to the time, tied to when the acts occurred, because there was a big gap in time between those two things?
Yes, and I don't think it necessarily needs to tie into it, because again, my position, I should say, is that this whole thing was manufactured at the time, shortly before he was actually charged. So at the time that he was actually charged, so my position is that at the time he was actually charged, that's when the allegations were manufactured. So we don't know.
Right. So this goes all the way back to Justice Sullivan's earliest question, which is it an abuse of discretion when we're reviewing this to think that it was, in terms of a trial strategy, things that happened 5 or more years earlier before the accusation were not really going to be the strongest line of attack on the witness's credibility, that she then decides, 5 years after an unpaid bill to come forward with this allegation. Do you see what I'm saying?
I see what you're saying. However, it's not that 5 years after an unpaid bill. My position is that after the parents divorced and Mr. Antoine's contact with the family lessened, she was still reaching out to him to continue to do new repairs. So it wasn't the previous repairs that we're talking about from years before. We're talking about now, fast forward to 2009, after they've divorced, she's still reaching out to him and he's repeatedly refusing her requests. It was at that time, I think, that the straw finally broke the camel's back and caused these allegations to surface.
Okay.
I have two quick questions. One is, other than the defendant's representation and the New York driver's license, is there any evidence in the record to show that he was in New York?
Yes, there was testimony by Rebecca Antoine, his other niece, whose name is Rebecca Antoine, who I called as a witness during the motion for new trial. She testified to that fact.
Okay. And does she put him in New York at the time the incidents occurred?
Yes, she puts him in New York at the time the alleged there was it's one specific allegation, which is that occurred in 2007. We don't have a specific date, we just have the year. And she puts him in New York at that time.
Okay.
And the brother's affidavit, who he was also present at the motion. I think I put a footnote in my brief that there was a request for an interpreter. For whatever reason, the court did not provide one. So he was there, also willing to testify to that fact, but that information is in his affidavit.
And the other is, you've raised immigration consequences. Can you give us a Padilla type case that arises in the context, legal case, in the context where there's been no plea? I mean, this case went to trial. So where is the Padilla violation in this case?
Sure, and I concede that that's definitely not our strongest argument here. It's just there are several instances of things that trial counsel did, which in my view rendered him ineffective. This is just one of them, and I think that ties into the theme of his lack of preparation for trial. He failed to adequately discuss these things with his client. So my position is that this is the discussion about immigration consequences is just one of many examples of how counsel failed to effectively communicate with his clients, which deprived his client of being able to participate in his own defense, assist his attorney in preparing for his defense.
Thank you. I've extended your time enough, I think. Thank you.
All right.
Thank you.
All right. Thank you very much. Attorney Nguyen.
Thank you. May it please the court. My name is Mary Nguyen on behalf of the Commonwealth. I just want to start out with the notion that where in this case, the motion judge was also the trial judge as well as the trier of fact, where this was a jury waived trial, special deference is given to the judge when we're considering whether or not he abuses discretion in denying the defendant's motion for new trial. As I'll discuss further in more detail, summarily, the defendant merely lists subjective critiques of the defendant's of defense counsel's decisions during trial without a showing that they likely affected the trier of fact conclusions. So I think that the biggest issue with respect to the defendant's claims are the prejudice prong. Beginning with the bias theory, starting with the claim with respect to the victim and her brother engaging in inappropriate sexual conduct in 2005 when the victim was 10 years old. I want to start off with the premise that it's implicit in the judge's ruling is a finding that he credited defense counsel's testimony that counsel did not recall receiving this information, thereby implicitly rejecting Rebecca Antoine's testimony that she did tell counsel about the alleged incident. And I think that credibility determination in the law is clear that credibility, that the motion judge, who was also the trial judge, is the final arbiter with respect to credibility, but to support the judge's finding with respect to that credibility determination are the fact that there's inconsistencies in Rebecca Antoine's affidavit and testimony in this regard. In her affidavit, she says in 2005 that she found out that the victim was having sex with her older brother. However, her testimony is that it wasn't that she found out, it was in fact that she witnessed this. That is very inconsistent. Moreover, the details of this alleged incident were also inconsistent. In her affidavit, she claims that she found out that the victim was having sex with her older brother, where her testimony is different in that she's now claiming that they were merely touching each other. So certainly those inconsistencies were for the motion judge to consider and support his credibility determination, thereby rejecting Ms. Antoine's testimony. And then I know you didn't touch upon it with counsel, but my argument is in any event, putting aside the credibility determination, wherein the judge is the final arbiter with respect to credibility, there's this issue of whether or not, even if that evidence was believed, whether or not it was available to defense counsel. And I do spend a lot of time in my brief discussing how it's barred by the rape shield statute and how the defendant cannot show exception to it. And then and the focus is on the judicially recognized exception, that being bias. And the Commonwealth's contention is that where there is that 5-year time period that we're talking about, that really that is important from the Commonwealth's perspective because it shows the remoteness, the lack of nexus with respect to relevancy. There's no material tendency to prove a motive for the victim to fabricate these allegations of sexual abuse against the defendant 5 years later when she was 15. And the defense attorney in her reply brief tries to draw similarities with the Joyce case. You might recall that the Joyce case involved the victim being found naked in a car late at night with the defendant when she had just 3 months prior been found in a very similar scenario in a vehicle and was also arrested for prostitution with respect to that. And she also had a previous arrest with the same fact pattern 7 months prior in May. So it's important in Joyce that there was this closeness in time. And also that they resulted in arrests to give her a motive to fabricate the allegations of sexual abuse to avoid prosecution. So you have to start with a plausible showing that the circumstances existed. And in Joyce, there were two arrests. And moving on to the second, and I wanted, if I can, just take a moment to discuss the allegation that the victim hated the defendant when she was around 12 or 13 years old because the defendant caught the victim sneaking out of the house. So you heard evidence from Rebecca Antoine's testimony during the hearing that the victim was 12 or 13 years old at this time. And that's important because I didn't point this out in my brief, so I want to bring it to Your Honor's attention now. That actually undercuts the defendant's alibi theory. So if you believe Rebecca Antoine, she claims that the defendant lived in, strike that, but the defendant claims that he lived in New York from 2005 through 2008, yet Rebecca Antoine's testimony would have one believe that the defendant was in Brockton scolding the victim in 2007 or 2008 when she was sneaking out of the house at ages 12 to 13. So I just wanted to make the point that actually undercuts the alibi theory. But as referenced previously, that evidence.
Can I just stop you
Sure.
for one clarification?
Sure.
Have I missed anything? Is there anything other than the judge's one sentence or 2 sentence denial of the motion for new trial that explains the reasons for the denial?
So unfortunately, the trial file is missing. So when the Commonwealth attempted to recreate the file in filing its brief, the only thing that I could locate in the Commonwealth file is that sort of one sentence ruling.
Did you check with the trial court?
I did, and they were as of the time of the filing of the brief, were unable to locate the trial file, and I haven't heard otherwise.
Is there any reason to think the judge made, written findings?
Oh, we lost her.
If the clerk could stop the clock.
Yeah.
Yes.
Okay, I'm gonna mark that at
I'll contact.
7.5 minutes. This is unusual. We really have been sort of operating seamlessly.
It may be just that her cell phone battery died.
I hit pause for the recording.
Great. Well, I took the
Yeah, it was around 7.
7:30
Something.
is what, 7.5 minutes.
This may be ADA Nguyen. Hold on a second, please.
I hope so.
Hello.
Hello, Attorney Nguyen?
Yes.
Great. Okay, we're going to reset the clock at 7.5 minutes, which is where you cut out.
Okay, great. I just wanted to also alert the court that I got kicked off, so I can no longer see any of the. I cannot see anyone at this juncture. I can only hear everyone. If that is.
So what I will do is I will keep an eye out and I will shout if anyone wants to ask you a question, so you'll know.
Okay, thank you. So I think I left off discussing.
Hold on a second, please.
Hold on. We need to set the clock first and get us streaming.
I apologize.
And get us streaming again. I'll let you know.
Okay, we're all set.
Okay, we're ready to go.
Thank you. I had left off, I believe, discussing the proffer that.
No, whether there were written findings.
I'm sorry?
Whether there were written findings by the judge.
Oh, that's correct. Okay, so to my knowledge, I have not tracked down any written findings. I am not aware of any written findings. I certainly didn't find any in the Commonwealth trial file, but I am not certain whether there is or there is not. It wouldn't appear that way from my recreation or my recreation of the file, but as I indicated, I'm not 100% certain regarding that. But I'm happy to follow up after oral argument with the trial court and look into that as well. I hope that answers your question.
Please do, and that should be obviously an effort that fully involves Attorney Joseph, so that you can be both satisfied if you do find anything that those are.
Okay.
And Attorney Joseph, having brought the motion, may also have her own views, but I neglected to ask her the question, so I'm sure you'll work it out and send us either findings or a letter.
Thank you. And if I may move on to the proffer regarding, so I think I last spoke about the proffer regarding the victim hating the defendant and how that undercuts the defendant's alibi theory. I want to then move on to the fact that that evidence is actually helpful to the Commonwealth case, because that sentiment by the victim, if believed, coincides with the last incident of sexual abuse by the defendant when the victim was 12 years old. With respect to statements the complainant made at a meeting held prior to the same interview, as reflected in the DCF report, the Commonwealth contends that that is a speculative reading of the DCF report that fails to adequately raise the issue of bias or motive as to the victim with respect to her allegations of sexual abuse by the defendant. And as I indicate in my brief, a fair reading of the report is that she had reservations about speaking to the police and testifying in the future. She wanted more information from investigators before she made her decision, and that she was weighing the pros and cons with respect to testifying in the future. And I also wanted to note that counsel had indicated that the only evidence was the victim's testimony and there was no corroboration. I just wanted to point out that, in fact, there was corroboration in the form of first complaint evidence when she was 15, and the testimony with regards to Ms. Barros that testified subsequent to the complainant. Now, with respect to the renovation work, that was from the review of the record, the claim that the mother was insisting that the defendant complete renovation work in her home free of charge, which the defendant declined to do. That was in 2009. And this evidence was proffered by the defendant's self-serving affidavit, along with evidence from Rebecca Antoine, who does not appear to have firsthand knowledge of this. There is no affidavit or testimony from the victim's mother. The Commonwealth's contention is that this is also a tenuous bias theory. First, where is the connection to the victim? And then it also requires acceptance of the idea that the degree of anger from the defendant's failure to do repair work without compensation was so intense on the part of the mother that the mother would direct her daughter to bring out false charges and then direct her to testify falsely in a criminal case. And moving on to impeachment, the method
Counsel, if before we get to impeachment, could we talk about the head injury issue?
Sure.
Yeah, imagine the defendant had not testified and the Commonwealth had tried to get in that the defendant had a head injury, and the defendant had objected as, potential propensity evidence, and that it was not relevant to guilt or innocence. Isn't the head injury evidence, isn't that playing with fire here? And
so as I indicated in my brief, I do argue that it's relevant, at least to provide context to the defendant's trial testimony. But I think, if I may, I think that the bigger issue is that there's no showing that the evidence of the head injury influenced the judge's conclusion. So there's that prejudice prong that I spoke of in the beginning, and that is when you look at how that evidence played out, it was minimal. When you consider the limited use by the prosecutor, her question was limited on cross-examination with respect to that subject matter. There was one sentence in her closing argument, which was 5 pages of transcript. And then also when you consider the defendant's closing argument as a whole, he only made one reference. Defense counsel only made one reference to that evidence in closing, and also wanted to address counsel's contention that there was no defense. To the contrary, defense counsel appropriately followed a defense that is very, if you will, common in these types of cases, where he appropriately focused on arguing that the victim's testimony was uncorroborated, and then also asked questions during cross-examination of the victim to elicit her failure to earlier disclose sexual abuse to further cast doubt on her credibility. So those are that was the defense, and that was certainly appropriate. And so the head injury evidence I would argue was minimal, and there has been no showing by the defendant regarding prejudice and it influencing the judge's conclusion as trier of fact. And I hope, does anyone have any questions with respect to the head injury before I move back to impeachment?
No, but I'll note that you have about 18 seconds left.
Oh, okay. So I just wanted to say, as I outlined in my brief, that those methods simply were not available to defense counsel. Specific instances of lying are not admissible. So the statements that she made with respect to sleeping arrangements of her cousins and her brother in the DCF report simply were not available, nor was there any prior inconsistent statements by the first complaint witness to which she could be impeached by. And in any event, there was no prejudice shown by the defendant or that evidence with regard to additional facts that Barrows testified to with respect to first complaint was before the charge fact.
We're going to have to leave it there. Your time has expired. Let me just see if there are any other questions. No, I don't see any. Thank you both for your argument. And the case is submitted.
Thank you.
Thank you.
Thank you. The case is now being recorded.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court. Although we are hearing this case in this electronic format or digital format, I don't know what's correct, because of the ongoing pandemic, all of our ordinary rules in the courtroom apply, and specifically that each side gets 15 minutes to argue with no rebuttal. And with that, I'm going to call case 2019 P1596, David M. Kane versus Mary Louise Woodford. Attorney Aceto, we're ready whenever you are.
Thank you, Your Honor. May it please the court, justice of this panel, my name is Greg Aceto and I represent David Kane in this matter. This is before you as a product of countervailing motions for summary judgment in the probate court. The issue really is, the sole issue really is on the issue of legal issue of self-dealing and the conduct of the trustee in this matter. In this case, I think upon reviewing the briefs and the statement of undisputed facts, you'll see there's really four general areas of fact that are in dispute. One, I would say, is the fair market value of the property at the time of the sale. The second one is the settler's intent when she created the trust and the parole evidence that would illuminate that intent. For instance, the use of the property for all 5 children continuing in perpetuity. The language of the terms, of the specific term, which is that whether or not personally interested, means what the defendants have asserted it means based on the use of parole evidence to clarify that issue. And the fourth issue of fact is the trustee's conduct. The trustee's conduct has been set forth in our brief and in the statement of facts. It rises to the level of bad faith. Was it in violation of the terms, the express terms of the trust?
Counsel, before we get into the weeds, could you address what interest your client has at this point? By that I mean, is this at this point all about the money and what share your client is due, or is he still interested in some kind of specific performance kind of remedy?
So if we had had the opportunity to present evidence, it would have come in at trial that this was, in fact, a lot of the evidence was stipulated to in the settlement and the statement of undisputed fact that this was a family trust created by the mother of the two parties.
No, we understand that.
Right. Well, I'm kind of providing the background for that, that in actuality, he intended to continue to use the property as a vacation home as it had been used for almost 15 years until the time that his interest was terminated. So it's not just about the money. In fact, Judge Monks asked that specific question. It's not about the money, although he has been shortchanged on that, which is pretty clear, I think, from the record. But the real issue is that he intended to continue to use the property, and he had used it right up until the time that he was barred from using it. And shortly thereafter, his beneficial interest was terminated. So there's no question that this was a family trust and it was set up by the mother to continue so that all 5 of her children could continue to use it. So
When the mother was alive, she was the sole trustee. Is that correct?
that's my understanding, Judge, and that's what we stipulated to in the statement, yes.
So as long as she was operating within the powers delineated under the trust instrument, she could make whatever decision she wanted, including allowing each of her children to have time to use the apartment, the condo, as a vacation property, correct?
That's correct. That's my reading of it.
Why is her decision as to how to exercise her power under the trust instrument, why does that bind the subsequent trustees on how they, as long as they're working within the powers they have under the trust instrument, why does the mother's course of conduct limit how the subsequent trustees can act?
And that's a good question, Your Honor. And my answer to that is that when she was alive, she wanted the ability and the flexibility to make determinations about it. But I believe that her intent, which would come out at trial, her intent was to make sure that all 5 children continued to use the property.
You understand my question is, once she puts it into a trust, her intent, her intent is really sort of off point, isn't it? Because she gives the trustees the power to do whatever she gives them to do. It says what it says. And as long as the trustees operate within the confines of the trust language, why isn't that the end of the story? It doesn't matter what a previous trustee did. A previous trustee may choose to exercise his or her power in one way, and as long as it's within the delineation of powers under the trust instrument, that will be okay, but it doesn't mean that the next trustee needs to do the identical thing, does it?
No, but in this particular case, she did not grant herself specific language of self-dealing as a trustee. It was this vague language that said whether or not personally interested. And so as I tried to set forth in our brief, what does that really mean? Well, I'm not sure anyone really knows without testimony from some of the family members, because if you compare the language in this to the language in Steele and any of the other cases cited, it's not to the same degree. And Steele,
isn't the right answer to the question you were asked that you're not looking for her intent as trustee, you're looking for her intent as settlor?
I think that sounds right to me, Judge. Yes, that would be the intent as a settler, was to ensure that this property would be used by all 5 members, which is why she granted the beneficial interest to all 5.
Do you have any case that says we look to the grantor's intent to get behind the language of a trust instrument, if a trust instrument is unambiguous?
Yeah, and I cite to those in my brief, Judge. And it's also, and I'm not sure how your feeling is about rounds on trust, but in rounds on trust, it talks about the same thing, that if there's vagueness to the language in the trust, it requires the consideration of parole evidence to determine what the settler's intent was.
Sure. So what is the language that you say is vague such that we would look to intent to determine the uses of vacation home for each child?
So I would look right to the powers language in the trust, Judge, where it says, again, whether or not personally interested. There's a vague clause at the beginning of the introduction of the trust to the powers. And I submit that if Ms. Kane, the mother, the settler, was interested in eliminating providing the authority for self-dealing, she would have specified something to the language that's in Steele. And in this case, at the end of the introduction in Article 5 to trustees' powers, the trust simply says, comma, whether or not personally interested in the exercise. I would think if the settler had the intent to do that, she would have said, and can self-deal. Nowhere in this document does it say.
What does that have to do with the vacation usage? Do you agree that a trustee, that whatever trustees, had the power under this trust instrument to sell the unit to a third party at arm's length, and all the children's vacation rights to it would be extinguished?
No, I don't believe that they had the authority to do that without the beneficiaries agreeing.
Where is the trust language for that?
Well, I think it goes back, so there is no language in the trust itself, because I think when this was written, she wasn't considering her demise, but I think if one considers the settler's intent, it was to allow her children to continue to use this vacation home. I don't.
No, but that's not my question. My question is, under the trust instrument, could the trustee at any given time sell the property to a third party arm's length transaction at fair market value, and thereby eliminating the beneficiaries or the children's abilities to use it as a vacation home?
And I understood that question, Judge. And what I'm saying is that I don't believe that that was what.
And I asked you for language in the trust document that prevented that. Is there any? Because I'd like a cite to the record. I didn't see anything.
And I agree, Judge, there is no specific.
Okay, the mother could have done that, the mother could have done that, and any successor trustee could do that. It seems to me that your argument really, what really it boils down to is whether or not the price that the defendant paid to ultimately transfer the remaining beneficial interests to herself was not fair market value. Everything seems to me to turn on that in your argument. If she had transferred the property to herself at what you claim to be fair market value, what here would be, what in the trust instrument would have prohibited her from doing that?
Well, it would be, so if she sold it to a third party, what would prevent her? Probably nothing under the terms in the trust, Judge.
Okay, so then, so what under the terms of the trust prevents her from doing that if the transfer to be to herself, if it was at a number you agreed was fair market value?
I would still say that the transaction and the case law that I cite is very clear on this, that the transaction then would be subject to intense scrutiny to determine that this is in the best interest of the beneficiaries, that it's advantageous is the language to the beneficiaries. And I don't believe that they could prove that it was advantageous to the beneficiary, especially where Mr. Kane has indicated he didn't want the property sold. That's where the self-dealing comes into play.
So what is your best case for the proposition on its facts that where we would have said this would not be allowed if the transfer were at fair market value?
My best case, Judge, would be to look at the cases, Boston Safe versus Seaford, King versus Nazaro, which is almost the exact same fact pattern. And even in Steele, they talk about the duty of loyalty and that self-dealing is not allowed unless under stringent circumstances. And so in this case, you have to look at what was advantageous and beneficial to the beneficiaries. The only remaining beneficiary was Mr. Kane, and he opposed the same.
Well, the defendant was the beneficiary too. She was the major beneficiary.
Correct, but I don't think the case is distinguished between who's a minority holder and a majority holder.
Okay, but you said he was the only beneficiary, and I just wanted to make sure he wasn't actually the only beneficiary.
I apologize, I misspoke. He was the only third party other than the trustee who obviously owned 80%, Judge. I agree, so I misspoke on that. So he's the only beneficiary other than the trustee. And
Counsel, when co-owners can't agree on property, the standard route people typically go is partition. Did partition come up as an option during the course of this case?
No, it did not, Judge. There was discussions early on. The trustee sent a proposal to Mr. Kane. I think some of this is in the record, but I don't believe it all is. The proposal was made to buy his interest. He refused because he said he wanted to continue to use it. The trustee bought the interest from two other third-party beneficiaries there, wherein she acquired this 80% interest, and from there she appointed herself as trustee, and then she barred Mr. Kane from the property, and then she sent him the sale instrument indicating that she had sold the property. So to me, that subjects her to intense scrutiny because she was self-dealing. And when the court looks at that, I would think that it would draw into question her ability to sell to herself. If she sold to a third party, well, that's a hypothetical, but if she sold to a third party, obviously would not give me as much grounds to challenge it. The issue is because she sold to herself, and this was not done at arm's length, that it's subject to intense scrutiny under all the cases that I cited. And here, where she paid two other beneficiaries $100,000 and only was willing to pay my client $67,000, I think it suggests the arbitrary and capricious nature of this transaction.
How do you know that what was sold to, what the offer to the others was not at a premium?
I don't know that. I don't know that. But she sold it to them. That's not even in dispute. She sold it to them for $100,000. The interest.
Right, but what I heard you say earlier, that offer was also made to your client.
I believe that it was, Judge.
The same offer was.
Yes.
And one thing that's not clear to me in the facts, is there a total of 5 siblings or 4 siblings?
There is, Judge. There was 5 siblings in the beginning. They each owned 20%.
Right. So she bought out 3 of the others?
Yes.
Some places it says 2, but I think if my math is primitive, but it would need to be that she bought out 3 others?
Yeah, she bought out 1 at the very beginning, I believe, Judge, within weeks of the ownership interest being structured based on the settlement in the probate court on a totally separate matter. She bought out 1, and then the reason the record says 2 is that she bought 2 out very close to when she had this dispute with Mr. Kane. And that's why the record says 2, but there was really 3 purchased over time. And so
then I have just one further question on the facts. So she spent $300,000 to buy out 3 siblings. And then she sold the remainder for the $375,000 to herself. That she paid that money into the trust, and then your client got 20% and 80% was returned to her. Is that how that worked?
Well, I think some of that question, Judge, would be more directed at my brother counsel, because I'm not exactly sure what happened with that. I don't think that's part of the record, other than I recognize that she then sold it to herself. I'm not exactly sure how she derived that $67,000 number that ultimately was forwarded to my client in a check. But I'm not sure also that first purchase was $100,000. That's not part of the record either. And so I don't know that she paid $100,000. I don't think it's clear on the record exactly what she did pay for the first 20%.
Gotcha. Let me see if there are any other questions. No. Okay, thank you.
Thank you.
Attorney Solomon.
Morning. May it please the court. My name is Charles Solomon, and I'm arguing for the defendant, Mary Lou Woodford. Before I begin, in terms of addressing Your Honor's last question, the undisputed facts are that the property was sold by the trustee, the defendant, for $375,000, which was the average price of 3 independent appraisals that she had procured. And again, the undisputed facts that were submitted in summary judgment reflect that there were expenses that the trustee had incurred. And after deducting those expenses, the distribution to the plaintiff was the amount that was actually tendered via a check was 20% of the net proceeds of the difference between the $375,000 and the expenses that the trustee incurred.
Counsel, putting aside the expenses, why isn't the $100,000 for the 20% shares the best evidence of market value in this case?
Your Honor, market value is not the material issue in this case.
No, I understand the argument. Just answer that question, please.
Well, I mean, the market value was, to the extent market value was material, the market value was determined by the fair market value is determined by 3 independent appraisers.
I understand the argument. Why isn't the $100,000 shares of a transaction willingly entered to by buyer and seller the best evidence of market value in this case? The 100,000 for 20% shares.
Well, 2 things, Your Honor. I guess as Justice Wolohojian sort of inferred in her question, we don't know what the facts are in terms of why the defendant paid or offered $100,000 to each of her siblings. It's not in the record. There's no facts one way or the other. One could infer that she paid, that in order to become the majority beneficiary, so as to exercise the rights that the trust instrument affords the majority beneficiaries in terms of choosing who the trustee is and treating the trust property as though she owned it, which is what the trust instrument allows one to do once one is the trustee. That she could have paid a premium over and above what the fair market value was. What I would suggest that the fair market value is best determined by the 3 independent appraisals that were procured. One of which was an appraiser that it's undisputed that was.
Why isn't that a jury question?
If fair market value was the material issue in this case, Your Honor, then I think it could be a jury question. But for reasons that I'll explain and that are set forth in our papers, we do not believe that fair market value is a material issue in this case, as Judge Monks noted in her decision. And the reason that is, Your Honor, I think that this case really turns on 3 provisions in the trust instrument. Two of those provisions are exculpatory provisions that exempt the trustee from liability for everything other than really intentional, egregiously wrongful conduct. Those are Articles 6 and 12 of the trust. And the third provision, Your Honors, it expressly allows the trustees to enter into transactions with the trust, such as the sale of the trust assets, even if the trustees have personal interest in the transaction. Now,
but counsel, in any sale, the trustee is going to have a personal interest because she owns at least 20% and possibly more. So does that necessarily cover the situation where you're selling the property to yourself? And in other words, you can put a very different gloss on that provision in terms of treating it as if, she were the property owner.
Well, it's not necessarily true, and it wouldn't be true under all circumstances, Your Honor, that the trustee would also be a beneficiary. The trustee can be a beneficiary. The trustee need not be a beneficiary. The majority of the beneficiaries get to choose who the trustee is. They could choose an independent trustee. So I'm not sure. Forgive me if I'm not understanding your question, but this basically says this provision says irrespective of whether or not you're a beneficiary, you are allowed. Article 5 says you can engage in transactions even if you're personally interested.
No, I understand that. That does not necessarily translate, at least to my mind, as saying, and you can self-deal however much you want.
Well, Your Honor, first, I would suggest that the plaintiff of the case didn't make that argument in its papers, that provision was ambiguous. But if there was any doubt about it, Your Honor, you would look to Article 7, which says the trustee may act with respect to the trust property as fully and effectively as if it was the sole owner thereof. So the trustee can do with this property, act with whatever it wants. And so
even freezing out someone who has a active 20% share, trustee can just say, nope, can't use it this year. I decide otherwise.
Yes, Your Honor. That's exactly right. That's what the cases hold, in fact, Your Honor. I mean, the cases, again, I was going to address the exculpatory provisions first, which by themselves are dispositive of this case. But in terms of I think Kelly versus Steele basically addresses Your Honor's question.
And what was the result in Kelly versus Steele?
In Kelly versus Steele, the trustee was found not to have breached his fiduciary duty where he acted, Your Honor. In that case, in Kelly versus Steele, the trust.
I thought the result in Kelly versus Steele was a new trial.
It was a new trial, Your Honor, because because the facts were that needed to be determined, I think, had to do with the amounts at issue. I think they had to do with whether or not the trustee acted arbitrarily or capriciously. So
I understand that, but it went to the jury. The appellant in that case was looking for a JNOV, and he or she didn't get it.
I have a more fundamental question about Steele.
Yes.
Which is, Steele had a trust that contained the following language. Quote, in dealing with the trust race and management thereof, the trustee shall not be held to the usual standard of care for trustees, but only to the standard of care of ordinary individuals dealing with their own property. Can we agree that that language does not appear in the trust in this case?
We can. I think that's right, Your Honor. But with all due respect, I think the equivalent language is there. That is, the trustee may act with respect to the trust property as fully and effectively as if it was the sole owner.
Well, that's in the title section. That's in Article 7 title. And I think it would have to say that in order to be able to pass title. I think you've correctly focused on Article 5, which states whether or not personally interested in the exercise thereof. And my question is whether or not that phrase can be made to carry the same weight with respect to an abandonment of the fiduciary standard as the far more explicit language in Steele. This is really a variation of Judge Milkey's previous question, which is it may give the trustee powers to do things, but does it really relieve the trustee of his or her fiduciary obligation?
Your Honor, I think that the thrust of Steele, putting aside sort of the specific language in Steele, it is that the principle is embodied in the uniform in the uniform trust code. Right, it's Chapter 203E, Section 802, and Section 802 says when a transaction like this shall be voidable, right, and it shall be voidable unless, and it says, one, the transaction was authorized by the terms of the trust. This transaction is authorized by the terms of the trust expressly.
Well, that's really what we're deciding, though. We're deciding whether or not personally interested in the exercise thereof means, and whether that constitutes a trust declaration that the Steele standard applies versus the ordinary fiduciary standard. And I think that's kind of the very first threshold we may have to cross, not necessarily, but we may.
Right. I mean, I would argue, Your Honor, that the language "not personally interested in the exercise thereof" is not vague or ambiguous. Which has never been argued. So I would argue that argument is waived. But I don't think that it is. I don't think it is. I would argue that it's not vague and ambiguous, and that it only has one meaning, and that means that the trustee, even if they are personally interested in the transaction, can engage in the transaction at issue.
Counsel, even if. Go ahead.
This is very quick. Do you have any authority, either in a Massachusetts case and out of jurisdiction case, the restatement of trusts, that stands for the proposition that that language means what you have said it means?
Not off the top of my head, Your Honor. I mean, there are a couple other cases that have applied Steele, and so I would want to go in, and I don't think all the cases have the exact same language, and I
think that's the problem.
Well, but other cases, including a case in which a panel of this court ruled, the Forbes case, upheld the principle of Steele. And I'd have to look. I don't know off the top of my head whether or not the Forbes Trust had the language on which Your Honor is focused. But either way, again, coming back to the exculpatory provisions of the trust instrument, right? Kelly says where the trust contains such exculpatory provisions, a trustee will not be liable absent proof of bad faith and personal and willful malfeasance or fraud. And Kelly made clear this is a really high standard, Your Honors.
Okay, so how does the freeze out not count as bad faith?
When you say freeze out, Your Honor, I mean this isn't a case. You under the 20% holder. The 20% holder was tendered a share of the proceeds from the sale of the trust. So,
as I understand the record, the 20% owner wanted to use the property as he is typically has done, as I understand it, for a vacation. And your client said,
just as a point of clarification, he's not a 20% owner. He's
beneficial owner.
He has a 20% interest in a beneficial interest. The owner is the trust. And I don't know that, well, go ahead.
The 20% beneficial owner asked to use the property, and your client said, nope, not this year.
That's correct, Your Honor. That is in the record. That's the only fact that is in the record. Although I don't think it's in the. I'm not sure it's in the undisputed facts that were presented on summary judgment. But there is evidence in the record of that occurred on one occasion. But again, you know, you'd have to ignore the provisions of the trust that grant the trustee the right to act with respect to the trust property as if it were the sole owner thereof, in order to basic.
Counsel, even if you're able to whittle down the extent of the fiduciary duties owed, even under ordinary contract law, you have the covenant of good faith and fair dealing. Again, outside the fiduciary context, you're not a little outraged by the takeover of the property here?
No, Your Honor, the defendant owned an 80% interest in this property. The logical extension of the questions that you're asking is that so long as a beneficiary of even a minute interest wanted to continue to use this property, that would control the will of the majority, despite what the trust says, and that the property could never be sold.
Why isn't that why God created partition actions?
But this is not a joint ownership situation. This is a trust.
I think that's right. It's a completely different set of circumstances. I mean, again, the law of trust is I'm sorry. I note that my time has expired, Your Honor.
No, you can answer Judge Milkey's question.
I mean, I do believe that the law of trust is very different than the law of real estate. And the law, you know, there are different rules that apply to joint owners or owners by the entirety, and the law with respect to trusts, which is mostly governed by fiduciary duty, which is very largely derived under the law by the actual language of the trust.
I think we'll have to leave it at that. Are there any further questions? I don't.
Thank you very much, Your Honors.
Thank you both. It's a very interesting case. We've been helped by your argument, and the case is submitted.
Thank you.
Your Honor.
The case is now being recorded.
Good afternoon. Welcome to this sitting of the Massachusetts Appeals Court. Your panel for this sitting is Justice Milkey, Justice Sullivan, and myself. Although we are sitting in this virtual format because of the ongoing pandemic, the ordinary rules of argument and in our courtroom apply, which include that each side is limited to 15 minutes without rebuttal. With that, I'm going to call case number 2019 P1846, Joanne Zullo versus Loretta Zullo.
3 errors of law. First, the trial court applied the wrong standard. Second, the trial court erroneously relied on a presumption of a gift after Loretta tendered evidence to rebut that presumption. And third, the trial court erroneously concluded that the record contained no evidence concerning her husband Jerry's intent. Let me start with the legal standard. The trial court treated knowledge of who was on the title and awareness of title as dispositive of the ultimate issue in this case, whether or not Loretta and Jerry intended to make a gift. That was error. The law is...
Counsel, isn't it fair to say that a lot of the judges focus on your client's knowledge of who was on the deed, a response to the fact that your client presented the issue as she always assumed that she was on the deed and was surprised in the end to learn something else?
I respectfully, the answer to that is no. Loretta was surprised that she was not on the deed, not that Vincent was on the deed. The testimony was that shortly after the purchase, Vincent asked to be put on the deed. The tax bills show Vincent's name on the title to the property. So the point here is not that Loretta was surprised by Vincent's name being on the tax bill of the deed. It's that she was surprised that she and her husband's name were on the deed.
Yeah, and the judge, may not have made findings as to every issue in contest, but I think it is fairly clear that she rejected your client's claim of innocence in terms of thinking that her name was on the deed.
It wasn't a claim of innocence. The trial court did find that Loretta knew that her son was on the deed. And the judge made a mistake of law by conflating knowledge of who was on the deed with the ultimate issue of whether or not a gift was intended.
When the judge makes a finding contrary to essentially the judge discredited your client's testimony about who she thought was on the deed. And oftentimes credibility determinations have more than just an effect on the single fact at issue, but slop over generally onto the credibility of the witness. So here, and I think this is related to Justice Milkey's question, is why is it that when the judge discredits your client's testimony regarding who she thought was on the deed, that's not also a credibility determination that might bear on your client's testimony regarding whether she thought she was making a gift?
The answer to that question is that the court didn't make a credibility determination about the gift. The judge didn't go far enough. She didn't complete her analysis. The authoritative courts hold that a resulting trust can be imposed even where the person furnishing the purchase price knows and agrees that someone else is on title. The court did make a credibility finding about Loretta's knowledge about who was on the deed, but that's not enough to decide this resulting trust case. The judge needed to go further and find a gift.
Excuse me, so the remedy for that would be we would ask her to make an additional finding with respect to the credibility on the assertion of the gift. We would just say, look, there's a finding missing. Would you please make that finding?
I think the case should be remanded and the following instruction should be made. That there needs to be an express finding about credibility on the testimony with respect to the gift. The judge also needs to assess the circumstantial evidence that applied to both Loretta's intent to make a gift as well as Jerry's intent to make a gift, and make findings whether those are consistent with an intent to make a gift or not. And third, the trial court needs to be corrected with the conclusion by the trial court needs to be corrected that there's no evidence on this record to show Jerry's intent. The case in this regard resembles a Supreme Court case, Chekovich, which is cited in our papers. The case is almost
who had the burden of proof on that issue?
On intent to make a gift?
Right, on the I forget everyone's name, but the dead husbands.
We have the burden to rebut the presumption, and our position is that the presumption was rebutted by circumstantial evidence that authoritative courts, including the Supreme Judicial Court, has found sufficient to rebut the presumption. The Chekovich case is almost exactly the same case as we have before us this afternoon. In Chekovich, property was purchased from foreclosure. Purchase price was funded by father and mother, but the deed was taken in the name of son and daughter-in-law. At trial, the Supreme Judicial Court affirmed the imposition of a resulting trust, notwithstanding that the mother was dead, and the mother was, the court found, was the treasurer of the family, the head of the family finances. And even though the mother wasn't there to explain why the title ended up in the name of the son, and even though the father, the court also made an express finding that the father didn't have a good explanation about why the name of the, why the deed was in the name of the son and the daughter-in-law rather than the mother and father who furnished the purchase price, the court nonetheless affirmed the imposition of a resulting trust. And I think that case is on all fours with respect to the case at this morning.
Counsel, can we turn to the presumption issue, because you treat the fact of the parents putting the property into the son's name as creating a presumption, and then you say, oh, if there's any credible contrary evidence, the presumption evaporates and goes away. Isn't it the case that that is more than a presumption? It's actual evidence of intent. If I put my car into Judge Sullivan's name, that's some evidence that I intended to give my car to her, isn't it?
No, that's an incorrect statement of the law, Your Honor. The law is when it's not a family member, it doesn't matter whether or not the person who funded the purchase price allowed, acquiesced, or agreed that title should be put in the name of someone else. There's a different presumption when that person is a family member. It's a weaker presumption when the family member is an adult, there are other siblings, the gift's improvident. But once we put on evidence that rebutted the presumption, and our position is that we put on circumstantial evidence that was credited and accepted by the trial court judge, both concerning Jerry's intent and Loretta's intent, that presumption of a gift between family members disappeared as a matter of law.
Well, but I think you're missing, counsel, I think you're missing my point. Even if you're correct that the presumption disappears, isn't the fact that they put it in his name still some evidence of a gift? And in the end, isn't it up to the trial judge to weigh the different evidence on both sides and to make a finding?
I disagree with that statement of the law. Once the presumption disappeared, the burden is to show that it was not a gift, and that burden was on Loretta. And Loretta met that burden with both direct evidence as well as circumstantial evidence that the court accepted and agreed with.
But you agree with the general proposition.
You
agree with the general proposition that even if the presumption is dissipated, it doesn't mean that the evidence disappears. The evidence is still admitted and may be relied on by the judge. It's just that the presumption is dissipated.
I agree with that, the presumption should have been given no weight, and the judge should have weighed the evidence on both sides of the gift question. Weighed Loretta's evidence of the gift against the appellee's evidence of the gift. And I just would like to turn to Justice Milkey's question a few minutes ago. There was a premise behind that question that I disagree with that I want to clear up. There is nothing on this record that the family intended that the title be in the name of Vincent. What happened was the father, Jerry, was dead, couldn't testify at trial. Vincent couldn't testify at trial. And what we're left with is an 87-year-old woman talking about a transaction 30 years ago. She didn't have an explanation about why her son was on the title, but that is not fatal to her claim if you look at the Chekovich case, which is an SJC case from 1959 that's directly on point.
Hey, counsel,
I have a question, just one quick one about the presumption. I want to make sure I understand your argument. Are you saying that all you have to do is produce some evidence, whether it's credited or not, in order to have the presumption disappear? Or I think your opposing counsel takes the position that the presumption doesn't disappear until such time as credited evidence is submitted.
Justice Sullivan, the answer is it's the latter. The presumption disappears when credited evidence supporting a contrary finding is adduced. That's what happened in this case. In this case, the circumstantial evidence that was credited and accepted by the court rebutted the presumption of a gift between family members. That evidence
but not in the judge's view. The judge looked at all of the evidence and in total determined that the presumption wasn't rebutted. So we're back to my question. She weighed it and said the presumption's never, if I read her decision correctly, said, I don't think the presumption's been rebutted. You're saying that if any amount of evidence is credited, that's enough to lose the presumption and force it to a decision on the merits. I'm not sure that that means the decision would be that different, but I hear you that there wasn't an explicit finding on the gift.
The test is sufficient evidence to make a contrary finding. And I don't think that's what the trial court did. What the trial court did was relied on a presumption that had been rebutted. The trial court made express findings that credited the following circumstantial evidence, which is evidence that authoritative courts all consider about whether or not a gift was intended and whether or not a resulting trust should be imposed. That evidence consisted of the following: that Jerry and Loretta paid the entire purchase price. At all times, at the times they paid the purchase price of the condominium and all times thereafter, they had no other place to live. Jerry died there in 2011. Loretta lived there for the next 30 years.
Counsel, you've made all these points quite ably in your brief. I'd like to turn to what I call the elephant in the room, and that is your version of what the parties did here makes sense only to the extent that they were trying to hide assets from others, including most notably the IRS. There are suggestions of tax fraud all over this record. What are we supposed to do with that, to the extent you're asking us to countenance a scheme that is highly questionable?
There's no scheme here, Your Honor, and I agree that the opinion is riddled with innuendo, but there's an explanation for those innuendos. There was an IRS lien recorded on the condominium or against Jerry and Loretta, strictly speaking, after the condominium was purchased. The judge found that the purchase price netted to the family after the sale of the Linfield home was $69,000. The lien was $15,000 and the purchase price of the condominium was $37,000. So the $69,000 that the trial court found was the net proceeds going to the family was more than sufficient to both purchase the condo and to pay the lien. In addition, in the record, it's not trumpeted it's not mentioned at all, in fact, in the trial court's decision, that lien was released in 1999. Finally, if looking at the record, Loretta was not the person in the, just like Chenkovich, Loretta was not the person in the family that did the taxes. She relied on her husband to do the taxes. She didn't review the tax returns before they were filed and had no idea about this tax lien. There's nothing in this record that supports a scheme of tax fraud. And I agree that you could get that by way of innuendo from the way that the decision was written, but it's not, doesn't square with the record in this case.
So counsel, why would you set up the arrangement this way?
I don't have a good answer to that, but I don't need a good answer to that under the Chenkovich case. In Chenkovich, the mother, who was the financial mastermind of the family, was dead and couldn't testify at trial. Here, the dad, Jerry, he was a guy that did all the transactions that the court recited in its decision. Jerry was dead. He couldn't testify at trial, nor could Vincent. Vincent doesn't come to this situation with clean hands. Vincent took tens of thousands of tax deductions, and he couldn't testify about why they were appropriate or what was going on. The point here is that the mother doesn't have to have an explanation about why Vincent was on the deed or what was going on. The mother just has to prove by the preponderance that she did not intend to gift. And that's the teaching of Chenkovich, which is a controlling case in this case.
What do we do about the fact that there can't be any proof of Jerry's intent?
That's a great question, Your Honor. There is proof of Jerry's intent. The transaction took place 30 years ago. 2 of the 3 parties to the transaction are dead. Courts in this area rely on circumstantial evidence. And let me just give you a little context, and then I'll get right to your question.
Let's give the context, because you're over time, and just answer the question.
The answer is circumstantial evidence proves intent in this circumstance. The fact that Loretta and Jerry, simply put, the fact that Loretta and Jerry retained the principal benefits and burdens of ownership, and the court found that. The court found continuous occupancy. The court found that Loretta paid $14,000 for an assessment in 2012 when the purchase price of the property was $37,000. That circumstantial evidence is sufficient to meet the burden of Jerry's intent in this case. And again, I'd send you back to the Chenkovich case, where there was no direct testimony from the mother, who was the financial mastermind and the treasurer of the family.
We're going to have to leave it there. Your time has expired. Thank you very much.
Thank you.
Attorney Elavecki.
Good afternoon. May it please the court, my name is Suzanne Elavecki, and I represent the defendant appellee in this matter, Joanne Zullo. As did my brother, I'm going to refer to the parties by their first names in this case. That's not out of disrespect, but rather because not only the parties, but also other witnesses or third parties all share the same last name. So my client Joanne is joining us this morning via the YouTube, the YouTube stream. We're here after a bench trial wherein the lower court found in Joanne's favor. Notwithstanding the caption here, Joanne was the defendant in the lower court and is the appellee here. Both actions were instituted by Loretta. The decision was issued following a 2-day trial where the trial court had the ability to view and assess the witness's testimony and veracity. As the case law states, courts recognize that the trial court judge who has a first-hand view of the presentation of evidence is in the best position to judge the weight and credibility of that evidence. Here, the judge did so, and she ultimately held that the plaintiff simply was not credible on the key elements of this case. Now, while my brother is attempting to couch these issues as errors of law, they are, in fact, I believe, as the court has acknowledged, credibility determinations. First of all, on the standard of review, factual.
Can we just stop there? Because it is certainly true that the judge made certain explicit or implicit credibility determinations in terms of what the mother knew and so forth. That said, there is a factual contest in terms of the extent to which the parents treated the condo as their own. For example, I believe the judge credited the evidence that they paid directly for various improvements, including, for example, the installation of new granite. Granite is not cheap. Why isn't that some affirmative evidence that the parents never intended this as a gift?
Even if it is some evidence, Your Honor, the court obviously, the trial court obviously weighed all of the evidence. The trial court wrote in its decision about those issues, made findings about those, and also weighed that against Vincent's indicia of ownership throughout the parties' following dealings after the transfer of the property into Vincent's name. And it was looking at all of that, the fact that Vincent claimed the condo on his taxes, the fact that he paid, there are checks in the record, and I can point you to the record appendix at the precise page that show that it was Vincent's checking account that was the one where checks were issued to pay for the maintenance of the condo. But
isn't that all just, I mean, as I understand the plaintiff's argument, there's no dispute that Vincent was the owner of the condominium. None. The question is whether that came about as a result of a gift. It was intended to be a gift, or done for some other purpose and then just stayed that way. So the indicia of the, so Vincent sort of exercising all the rights and responsibilities of ownership doesn't really seem to me to bear directly on the point, because the point is the parents' intent in allowing Vincent to have title in his name. Am I missing something there?
I don't think you are, but one of the ways to find the intent is to look at how the parties treated the property after it was acquired, no matter whose name it was in.
So Vincent, I mean, if we accept it was given as a gift, he never exercises any real right to the condominium, right? It's the parents, he never has physical possession. Parents live there uninterrupted. There's no suggestion that's not supposed to continue, right? Everyone seems to think that the parents are going to live there as though title never transferred.
So at the time that title did transfer in 1993, his parents were maybe not officially elderly, but they had had a lot of life behind them. And I don't think it would be so unusual that he would hold that condo in a way that assists his parents through the remainder of their lives. It's not only whether it's a gift, but also whether it's an advancement, and that would be an advancement of an inheritance. I don't think that is out of line with these facts in the slightest. And again, the trial court did weigh all of this evidence and made the determinations that it made after weighing everything.
Just in a technical sense, how do we know the trial judge weighed this when the words that came out of her pen were that the evidence was not sufficient to overcome the presumption?
They're included as findings of fact. I think that does show that they were weighed. They were considered. She outlined everything that was considered in her decision. And I think very clearly addressed concerns with the areas where there were concerns. And as came up in my brother's argument, the credibility determinations do bleed through into everything. There were shifting theories and shifting testimony here, and including at trial when the plaintiff was confronted with her deposition testimony, it was clear that there had been changes in various different stories, also from the verified complaint to both deposition and trial, from saying, oh, I never knew his name was on the deed, I always thought it was me on the deed, to then saying, oh, well, no, actually, he asked me sometime after if he could put his name on the deed. And the trial court clearly discredited that testimony and said that is not something that I'm going to believe. It does not actually make any sense.
But what is the evidence other than the parents putting the property into the son's name that they did not intend this as a gift? I mean, getting back to Judge Wolohojian's question or comment, what are the signs that he treated this as his own when, for example, the property tax bill was addressed to him, but care of his mother?
Well, as the record reflects, that was actually the rent that was being paid by the parents, was taking care at that time, at the time of his death.
Is the only evidence of this paid as rent the letter from either you or predecessor counsel right before the case was initiated?
The evidence concerning the payments is in the record, but albeit convoluted. So there is evidence that initially there were payments made from a checking account held in Vincent's name only. Subsequently, Loretta's name was added to that checking account.
No, but I think what Judge Milkey is saying is there anything earlier that characterizes this as quote unquote rent before your predecessor counsel or counsel wrote a letter calling it that?
There was a lease that was entered into evidence. I have to look at the decision quickly to remind myself exactly how the judge treated it. It was either given limited weight or potentially no weight. So I would need to check that first. I don't want to misspeak. There was that. Otherwise, I think that once
It wasn't characterized as rent before then.
Not that I'm aware of.
Right.
Other than the lease, but those figures aren't equal, even if it was given weight or accepted. But at the same time, that shifts the burden in a way.
If you were to encapsulate for us, what facts distinguish this from perhaps putting title in the son's name as a matter of convenience for whatever reason, as opposed to putting the title in the son's name for the purposes of a gift, for giving it to him? What would be the facts that you would point to that would distinguish this one way or the other, that would show that it's a gift as opposed to doing it as a matter of convenience for some other purpose?
That would require me to sort of just make things up a little bit, and I'm loath to do that. I think if Vincent were around and able to testify, he would be able to.
I know, but unfortunately, we're all stuck with the record that actually happened.
Exactly, and there's no dispute.
Or fortunately, I don't know.
And this condo was acquired in 1993, and Joanne met the family in 1996. So she is not able to put forth facts about what happened in 1993. That was, unfortunately, due to circumstances, left to Loretta. And that testimony was not found to be credible. And I think that that is really the linchpin here. And, you know, the court clearly did consider the proper standard. It's cited throughout the decision. She did consider the Chekovich case. She cited it in a footnote. It wasn't that that wasn't considered. The Chekovich case and the ZULLO case are not the same because both are so factually determined. This relies on the testimony. It relies on the evidence. Here, there was no evidence of payments by Loretta of either the purchase price, which we accept the court's finding that Loretta and Jerry did provide the purchase price, but there were no documents to show that. There were no documents to support her testimony that there was this convoluted bill paying arrangement put in place of a checking account of Vincent's that she deposited cash, always cash, into. These were the facts that this case hinged on, and the court did not find that credible. And I do think—
Is that necessarily true? It's true the court didn't accept those allegations, but nor did the court, to my knowledge, expressly reject them. He didn't say, and I find she didn't fund it. There's a lot of cash floating around in this family. And I'm not sure the judge answered that question.
No, and on the issue of the payments in particular, I believe what the judge said was, even if I were to credit this testimony, so did not come right out and say, I do not credit, but there were other instances where the trial court did clearly say, this is not believable. I do not find this credible. One issue in particular, I know that there was an issue raised about the letter to her children in the appeal, and there's, you know, a claim by my brother that because this letter was a document, it's not afforded the same level of deference. I did want to point out, I wanted to take an opportunity to point out that in the case at issue, first of all, Commonwealth versus Tremblay is a criminal case, and the circumstances were very different. It's a recent case, 2018, so we don't really know how that is going to bear out yet. But what's crucial there is that the court says, unless, you know, if you're making a determination based only on the document, and here the court did not. The court actually held side by side the document and Loretta's testimony and said these aren't consistent. And that was only one of many places that happened. And that really is the through line here, where there aren't actually errors of law, but rather credibility determinations. And if your honors don't have further questions on that point, I did want to touch briefly on our request for attorney's fees.
I have a question about Jerry, the father, which is the judge relied as an alternative ground for her decision on the fact that there was little, if any, testimony about Jerry. And my question is, does it matter once he has passed away and the sole person holding a claim to this real estate is the wife? Does his intent, you seem to think his intent matters, does it?
It does matter, Your Honor. Even in the case of Chekovich, the court says that what is at issue here is the party's intent at the time of the transfer. So that would be the intent in 1993. And Jerry was there for that. He was one of the parties. There was testimony by Loretta that Jerry and Vincent had multiple conversations.
I understand, but I'm just wondering how long that plays out into the future when the person who made the transfer is no longer alive and his interest is transferred to someone else.
Loretta's testimony was very clear that the property and the funds that was used, according to her testimony, to acquire the property were jointly held funds, and that the property, in her view, according to her testimony, not waiving any rights there, was held by both Jerry and Loretta, and that they owned it together. So his intent was very crucial to this, and all of the cases are clear, and I don't believe there's any dispute about this, that what's at issue is the intent at the time of the purchase and not what takes place over time later.
Great, we're gonna have to leave it there because your time has expired. And thank you both for your arguments. They were both helpful for us in this very interesting case. And with that, the case.
The case is now being recorded.
Good afternoon. Welcome to this sitting of the Massachusetts Appeals Court. Today, I am sitting with Justices Milkey and Sullivan, and my name is Gabrielle Wolohojian. We are hearing this case in this format because of the ongoing pandemic. However, all the ordinary rules of oral argument apply, including that each side gets 15 minutes to argue and there is no rebuttal. With that, I'm going to call the case of 2019 P 1507, TAMMY LARACE versus Wells Fargo Bank. And I think it's Attorney Russell. We're ready whenever you are.
Thank you, Your Honor. May it please the court, Glenn F. Russell Jr. on behalf of TAMMY LARACE and Mark LARACE. The case is somewhat famous. It was at the Supreme Court almost 10 years ago. This is a carry-on from that matter where the financial entity has sought to re-foreclose. This is a matter that was on summary judgment in the land court. The land court judge based half of his ruling on issues related to res judicata and or issue preclusion related to a prior tri-title action. The rest of the opinion dealt with the defendant bank's use of GLC 244 section 14 and whether or not they complied with the strict statutory requirements of that statute. And there's many pieces off of that. There's also, and I understand that I've made this argument before, Your Honor, in the NIMS case, there is the obsolete mortgage statute claim in this, which I did file as, I believe, prior to the NIMS decision. If we have time, I would like to indulge, or you would indulge me in a little bit of that argument on that as well. There's a quiet title action that the LARACE has brought. And finally, there's a show cause piece to this that I'll address at the very end. So I just wanted to put that out as the outline. So to begin with, the res judicata issue. The plaintiffs, we feel that the judge misapplied the law. We feel that his determination that the tri-title case was determinative and precludes any further argument is misplaced. We base that on the fact that the Supreme Judicial Court has specifically ruled on what the context of that statute requires, both in Bevilacqua v. Rodriguez and Abate v. Fremont. Specifically,
Counsel, if I may, I'd like to kind of cut to the heart of that argument with you for a minute. but first let me kind of review the bidding and make sure that I have the facts straight. As I read this, there was the original quiet title action in 08, which was dismissed under the authority of Ibanez. And then the LARACEs brought the title action in the land court in 2012, which was dismissed in federal court as a 12b6. And I think you would say it should have been dismissed for lack of jurisdiction.
Correct.
Correct?
That's correct.
And then there's a superior court action in 2014, which is dismissed on statute of limitations grounds.
That's correct.
All right. So the argument that I think you're making here initially is that under the authority of Abate, since the case was dismissed for failure to identify adversity, that should have been a subject matter jurisdiction dismissal, which under Abate could not be res judicata in any sense on your current action.
That's correct.
Is that your argument? My question is, why doesn't claim preclusion apply after the dismissal of the 2014 action, to the extent that you try to tie your claims in the present case to the 2007 facts?
So to review, you're talking about the 2014 case?
No, I'm talking about your current case. Well, I'm talking about the 2014 case, yes. Why doesn't you have alleged an impropriety in the 2007 facts, which underlies your current lawsuit, right?
Well, to an extent, there's the new 2018 case is based on a 2018 foreclosure. It's a completely separate foreclosure process than what took place in 2007.
Oh, but in the interim, there's a 2008 assignment. How do you skip over the 2008 assignment?
Well, the 2008 assignment was part of the Ibanez case. And what the SJC stated in that case was, and they talk about it in detail, and I talk about it in the brief at pages 16 through 26, is the fact that that 2008 assignment, they admit it didn't take place on that date. They state in their pleadings. And in Ibanez, the SJC sets out the nomenclature in which they say that the first assignment was in blank.
Well, I understand that. Are you saying that the 2008 assignment was merely confirmatory and not a new assignment?
I'm not, yes, but that's backed up by their statements, and I can point out the record.
So if your theory in the current lawsuit is that the 2008 assignment doesn't add anything because it's merely confirmatory, have I accurately stated your position in the current lawsuit?
Well, there's a 2012 assignment.
Right, which is denominated as confirmatory of the 2008 assignment.
Correct. And then the 2008 assignment, they claimed in Ibanez that that was confirmatory. So all of the argument with the land court judge was that in his opinion, that because this assignment is now in place at the time of the auction, that that's sufficient. But that assumes that that assignment took place on May 17th or May or March or whatever month it was of 2008. But they admit that didn't happen. The statements throughout in 2007 and today, they say
so let me take your argument at face value. If I accept your argument at face value, that the 2008 assignment doesn't add anything, and this all turns on what happened in 2007, why doesn't the 2014 Superior Court action result in claim preclusion of your current claim, since you're saying that nothing after 2007 matters?
Because they have stated the 2014 case wasn't about foreclosure. It was a monetary action solely on monetary. There was no foreclosure at that time. This is a completely new statutory action.
Right, but you could you not have brought a declaratory judgment action then to forestall any future foreclosure? That's what the footnote, the federal court's footnote in the 2012, in the prior title action said. That was your remedy.
The tri-title action, which is RA 1274275, specifically stated the defendants try to make much of the fact that we're arguing about over the effectiveness of the assignment. In fact, what the judge said specifically was that the plaintiffs had failed to allege an adverse claim. It says plaintiff's petition lacks an essential element. So
I understand, but there's a footnote that says
the validity of that document.
But there's also a footnote in that case that says that your recourse was to bring a declaratory judgment action.
No,
which could have been brought in 2014 with the Superior Court action, could it not?
That would be an advisory opinion, Your Honor, because there was no foreclosure at that time. That would be asking the court to make a judgment in the future for an action that has not happened. That would be an advisory opinion. There was no foreclosure.
Why would it be an advisory opinion? Why couldn't? So we're getting a lot of feedback. So I'm going to ask Attorney Dellings if you can put yourself on mute and maybe see if that helps us.
You want me on mute?
No,
I'm
Attorney Dellings.
I'm sorry.
There's a little microphone. There you go. Thank you. Let's see if that helps. But why couldn't you, why wouldn't that be just an action to quiet title or some other declaratory? It's not hypothetical. It's not advisory. You're asking that there be a declaration of rights with respect to the party's interests in the case, in the property.
You mean in 2014?
Yes.
Because the reason why is the 2014 complaint was brought. I brought it in tandem. I brought the tri-title case to determine the title. The land court doesn't have jurisdiction to handle the other claims. So my thought was that the title would be decided in the tri-title case because at that time there was a dichotomy in the land court. There was the Abate case and there was the Varian case, which the federal court judge talks about at note 3 of his opinion at RA 1275. And in that dichotomy, during that period of time, I was let's put it this way, it was, would be considered appropriate to let the title play out in the tri-title case while I was doing the monetary claims in the Superior Court. And the reason why I brought the Superior Court claim too was the time statute of limitations was running out and I needed to file something quickly. I didn't anticipate the tri-title case taking that period of time. I didn't anticipate the Abate case staying this case while the SJC made a ruling on Abate and then they applied it to this case. And on that note, that goes to the res judicata argument because the First Circuit specifically affirmed Judge Ponzer's ruling that in fact, the plaintiffs failed to allege an adverse claim, which makes that a nullity.
All right, so why don't you address then the merits? Because res judicata is one of those complicated matters that could consume your entire argument. So
sure.
Tell us why you think the 2008 assignment is a nullity and any other issues on the merits that you care to address.
Thank you, Your Honor. The defendants have specifically stated out the nomenclature of their opinion on the assignments, and that can be found at RA 2018. They talk about the intermediate assignments. They talk about 3 assignments. This mirrors the SJC description of the same parties. So the SJC said at page 649, a transfer of a mortgage is a transfer of an interest in land that needs a writing. So they're also relying upon the pooling and servicing agreement. Now, page 651 of the Ibanez case, most of the financial industry, they say, well, look at it says right here, it says the loan schedule, it says may suffice, but the operative sentence occurs after that. It says, however, it must be shown that the entity assigning the mortgage loan under the PSA actually owned that mortgage. And back in the Ibanez case, they talked about the fact that they didn't show that the entity ABFC ever got that assignment. So nemo dat quod non habet. How do you assign something under the quote mortgage loan schedule to the trust that you never received? The SJC said, they said all of those assignments, they didn't supply any of the writings. They make the same exact argument in this case that they made in 2007. It's identical. And the SJC didn't rule on, they never made an ultimate ruling on whether or not it was valid. It was dismissed or was dismissed on a procedural ground. The 2007 case was specifically that they didn't use the statute properly. They didn't get into the actual ownership. This case, the LARACE family, on top of asking the court to do a declaratory judgment in count 1, they asked for a quiet title action. That
Are you talking about the ownership of the note or the ownership of the mortgage?
I'm talking about the ownership of the property. Yes.
No, well, there's two, we're talking about a note and a mortgage.
Correct.
Which ownership are you referring to?
The only proffer that they've submitted in a Rule 56 context was an affidavit. An affidavit by a gentleman who refers to business records. Business records 23378.
Regarding the mortgage, which is what is the issue.
Regarding the note. GLC.
And regarding the note,
yes.
Which under Sullivan versus Condor Capital, the affidavit would be sufficient, would it not?
It would not. It would not be sufficient. Sullivan v. Condor also, is Your Honor talking about the 18354B argument? Which is?
I'm talking about an affidavit that says we have the physical note being enough to establish that they hold the note.
But they don't say that. They say they refer to business records. There's nothing in that affidavit that says I personally viewed the note. He says I looked at business records. The business record is not a note.
Did you ask for the note in discovery?
They gave a copy. And even if I got it in
Did you ask to go see it?
I did not. They asked me to go see it, but that, Your Honor, that was after the foreclosure happened. The issue is whether or not they had it at the time of the first publication under GLC 244.14, which is what the SJC stated. So if they came in with it today, that would not prove that they owned it back at the time of the first publication. And I see my time is up.
Counsel, I have
any other questions? Yes.
Yeah, I have just one quick question. When was the last time your clients made a payment on the note?
Well, you know, Justice Milkey, I never stated that they didn't make a payment. I thought that this review is how and when the judge made his ruling.
Counsel, please answer my question.
Probably 12, 13 years ago. But that doesn't come into, that's got nothing to, we didn't say that they don't owe money. We said that they don't owe it money to these people. That's a different argument, Your Honor.
All right, I think we have your argument.
Thank
Attorney
you.
Dellings, I think so that we can reduce feedback, would you, Attorney Russell, please put yourself on mute now, and hopefully that will help us.
Absolutely. I can figure out how to do it.
There's usually a little microphone icon. There you go. Thank you.
May I proceed?
Yes.
I think I just froze. Good afternoon, Your Honors. May it please the court. My name is Marissa DeLinks, and I'm here on behalf of the defendant appellees, Wells Fargo as trustee and Auckland Loan Servicing. I would like to begin to address the res judicata argument just quickly. I think the court does have an understanding of why the land court was correct in finding that res judicata bars count 1 and count 7. I would argue, as I did in my papers, that we're dealing.
I have to stop you there. Reading Abate, if it was dismissed for failure to show adversity, that's a standing issue and it's jurisdictional. How do we bootstrap a jurisdictional dismissal into issue preclusion or claim preclusion?
Well, I do understand your point about Abate. However, Abate also found, and it is a requirement, it's an essential element of a plaintiff's tri-title claim to allege and prove they have record title. And in Abate, in that decision, the court finds that in determining whether a tri-title plaintiff has standing, it's appropriate to make a determination on the merits as to whether or not there is a record title issue. So
understood that happened in Abate. Did that happen here in the federal district court?
It absolutely did.
Did it adjudicate ownership?
It adjudicated ownership based on the fact that they didn't have record title, because the claim was, as it was presented, the very issue was that Wells Fargo did not hold the record title because the 2008 assignment had purportedly been declared invalid by Ibanez. That was the issue they raised, and the district court absolutely did decide that, Your Honor. But
are we talking here, when we're talking, if we are thinking of defect in standing as being quote unquote jurisdictional, sometimes I find the use of the word jurisdictional is used sloppily, or do you see this as a matter of subject matter jurisdiction or personal jurisdiction?
It's not a matter of personal jurisdiction.
You think it's a defect in subject matter jurisdiction?
It's interesting to say that. The adverse claim piece is a defect in subject matter jurisdiction, but when it comes to this issue of standing, it's preclusive of their ability to bring the claim. That's why it's hard. I guess it is subject matter jurisdiction, but it is, like you say, it's unusual to piece these things together.
It's a question as to whether the court has authority to adjudicate a claim where a person doesn't have standing.
Correct, I understand that, but the tri-title statute, as Your Honor is aware, is so archaic and so unusual. And in that particular statute, what's required is in order to proceed with the claimant has to plead and prove their record title ownership. So it's a bit of a different situation. It's not subject, the court does have subject matter jurisdiction to hear the tri-title claim. There's no question about it. But they have to be able to show and plead and prove those elements in order to proceed to the next question, which is the adverse title issue.
Right.
But I think, just putting that aside, it is an interesting question for the court and for us to consider. But I do think that Judge Sullivan was also correct that we have a claim preclusion issue with regard to the 2014 case that was brought, because at that particular time, even though my brother indicates that there was no foreclosure action that was pending, in fact, the record shows that Wells Fargo head trustee had initiated a 2012 foreclosure by issuing a new notice of default, and that's what prompted the 2012 tri-title action. In addition, everything, the 2008 assignment was on record, the 2012 confirmatory assignment was on record, everything was on record for the LARACEs to be able to bring their claim in 2014 to try to enjoin foreclosure based on this purportedly invalid 2008 assignment. And they failed to do that.
How do you respond to the argument that would have been premature and advisory in the absence of an actual foreclosure threat?
I disagree completely, because this case was actually brought before the 2018 foreclosure occurred. So again, this case was brought in order to stop the July 3rd, 2018 foreclosure. The 2014 action could have done the very same thing. That's what the point was, to try to enjoin any foreclosure in light of the fact that Wells Fargo as trustee purportedly didn't hold record title.
What would have been the appropriate vehicle? Is it a declaratory judgment action, a quiet title action? What is the vehicle?
I believe it would be a declaratory judgment action to try to enjoin the foreclosure, any foreclosure.
What was the time lag between the issuance of the Abate opinion in the SJC and the filing of the current case?
The Ibanez decision, Your Honor, I have it with me. Sorry about that. speaking for 1 second so I can give you an actual time. Yes, I do. Ibanez was decided by the Supreme Judicial Court on January 7th of 2011.
No, I was talking about Abate.
Abate, pardon me. Okay, Abate was decided March 9th of 2015. And this case was filed in 2018, June of 2018, I believe. So 3 years later. If I answered Your Honor's question correctly. I think even just moving past res judicata, which I do believe does bar this claim, count 1 and count 7, the claim fails on the merits. I understand that my brother continues to say that Wells Fargo as trustee admitted in Ibanez that the 2008 assignment was invalid. No, there was no such admission. I mean, he's looking at a decision that's based on arguments that were presented to the court at that time. At the time of Ibanez, the 2008 assignment had been issued, but Wells Fargo as trustee was dealing with a situation where they were trying to show that they were the record holder of the mortgage at the time of the 2008 foreclosure. And so they looked to try to determine whether they could show that through the transfer of this loan, through the securitization process to the trust. But it failed at that time to provide a mortgage loan schedule or any other document that the land court and then the Supreme Judicial Court could look at to say, okay, yes, the trust owns this loan. Regardless, as my brother pointed out, yes, the loan was transferred to the trust back in 2005. There's no question about that. We all agree. But in order for Wells Fargo as trustee to be the record holder of the mortgage, to allow it to foreclose and exercise the power of sale appropriately, there has to be a written assignment of this mortgage to Wells Fargo as trustee. That is the 2008 assignment. It's from option 1, and it assigns the mortgage to Wells Fargo as trustee. 2012 confirmatory assignment just confirms that assignment. Those were presented to the court, to the land court. In addition to that evidence, the Handville affidavit that was referenced by my brother, he testified to the fact that ANTOINE had executed in August of 2017, almost a year before the foreclosure occurred, the 244 Section 35B and Section 35C affidavits attesting to the fact that Wells Fargo as trustee was the holder of the note secured by the mortgage. Those documents were submitted to evidence by the land court. We also provided the post-foreclosure affidavit, the Pinty affidavit, as well as copies of the notice of sale, which Mr. Handville attested were provided to the LARACEs, which included the 209 CMR certification, 18.21A certification that certified that Wells Fargo was the holder of the mortgage pursuant to the 2008 assignment and confirmatory assignment, and that it was the holder of the note at the time the notice of sale was issued and at the time the foreclosure occurred. So all of that was submitted by Wells Fargo's trustee to the land court. In addition, you have my Wells Fargo's counsel arguing to the land court and telling the land court it was not relying on the 2005 blank assignment back in Ibanez. That was never the position taken. Those allegations that were made by the LARACEs in their complaint were denied by Wells Fargo in their answer. The request for admissions, they denied those requests for admissions. And then they, in their summary judgment papers, as well as before oral argument, Wells Fargo's trustee continued to say, no, our ability and right and entitlement to foreclose is based on the 2008 assignment, which is a valid assignment, and the confirmatory assignment, and the fact that we are the holder of the note and were at the time of the notice of sale and at the time of this foreclosure. So based on the merits, nothing else was submitted, nothing to contravene that record. Evidence was submitted by the LARACEs to avoid summary judgment on count 1 and count 7. And so we'd ask your honors to affirm that count even on the merits basis. With regard to count 3, which was mentioned by Attorney Russell, the obsolete mortgage statute, Justice Wolohojian, you issued a decision in NIMS. I think that dispels with that particular claim completely. And then, of course, Mr. Russell, on behalf of his clients, did petition for further appellate review. That was denied on July 27th of 2020. So I think count 3 is readily able to be affirmed. Count 2, that addresses whether or not ANTOINE failed to comply with General Statute 244, Section 35C, because the 209 CMR 1821A certification did not include a certification regarding the chain of ownership of the note. And our argument in our papers is essentially that's just an absurd reading, especially considering Massachusetts statutory law. A negotiable instrument, a note, can be transferred if it's endorsed in blank by possession alone. Our Massachusetts statute 106 section 3-205B, which is the section pertaining to negotiable instruments and notes as notes that are endorsed in blank. That's what our statute says. So to interpret this regulation to somehow require a chain of ownership of note to be included in it would just make no sense and leads to an absurd result. It's also beyond what 244 Section 35C requires, which is that a mortgagee should refrain from foreclosing unless it can certify that it is the holder of the note at the time it issues the notice of sale. So, and then
Counsel, how do you address your brother's argument about the interpretation of Section 54B? He argues that the bank's interpretation of it is too loose, and that you need, some kind of personal knowledge of having seen the document, etc.
All right, so that's interesting, because I think the only place that he raises this issue, the argument that he raises, Your Honor, I think is with count 6, that the land court should not have considered 35C affidavit because that is purportedly inadmissible hearsay. And I think the argument below by Wells Fargo was, well, no, it's presumptively valid under 184 section or 183 section 54B. But in fact, recorded documents that are recorded in the registry pertaining to that affect interest in land are under our common law. They are an exception to the hearsay rule. And this court decided that in Bartleman, which is cited in our papers, that is 94 Massachusetts Appeals Court 800. That was a 2019 case looking at the evidence. So I don't think that any court is, or the banks certainly, are interpreting 183 section 54B loosely at all. There are certain requirements that this court has recognized must be set forth in an affidavit. And in Sullivan versus Condor, my recollection is that those elements were not included in the particular affidavit in that case. And the affidavit, the matter was remanded back down in order to provide some other proof. It has to be the statute. I'm sorry.
How would a mortgagor ever get to go behind the affidavit? If the affidavit says we've had it and we've had it since the dawn of time, and maybe it's true and maybe it's not, and maybe the business records are complete and maybe they're not. As a matter of policy, shouldn't there be something that a bank is required to produce to actually establish that they held the note at the time that the critical action was taken?
Well, I think they do, Your Honor. I mean, here, of course, we produced the Handel affidavit, which, he attested based on his
Shouldn't
records.
there be a date stamp document somewhere?
Well,
when we remanded in Sullivan versus Condor, that was one of the issues. Could they produce something to show that they held it in their hot little hands at the time that the foreclosure occurred?
I think it's an interesting point, Your Honor. I mean, I think that if a bank testifies based on business records, based on their personal review of business records, they're also certifying to the court they have reviewed the document. They have reviewed the original note. And I can tell you from myself that when we actually obtain the original note endorsed in blank, when I'm here before you now, and it's in my vault. And foreclosure counsel does the same thing. So if we don't have it, that representation cannot be made to the court. And then there is a lost note affidavit or something else that's put forward. So
Let me check to see if there are any other questions. No. Thank you very much. It's an interesting and complicated case, and we were, both of your arguments were very helpful to us. So with that,